what do you got?
I think I can prove to a judge that both of these men had the mens rea.
What the hell is a mens rea?
It's a legal term the lawyers use. It just means the intention to commit a crime.
Okay, come on, let's go.
Mens rea?
Put the cuffs on him.
How could we have gotten mens rea? We take blood? Can you do it without taking blood? We both use condoms. How is this possible? I want to see a doctor. Can I have an independent blood test?
Money!
I feel sick.
What are you doing?
Mens rea! Oh! Oh! My God! No!
Hey, good morning, good afternoon, good evening, everybody. Wow, my mic is super hot, just like me. I am Legal Vices, and this is the channel that I like to call Legal Vices because we enjoy our legal vices here. Let me bring this up here so we can get rid of this super hot microphone. Yeah, there's only so much super hotness I know you all can take, and I'm glad you're here. While that's loading, it's time to. Oh, I have forgotten a beverage glass. Wow, we'll just have to wait for a while on that. Shame on me to forget me beverage glass. Okay, we have a change of plans here today, folks. I was going to be doing some motion hearings, previous motion hearings, reading some of the orders, some of the submissions from the people, but they've decided, I guess, to televise today's Melly trial, the hearing. There's a hearing today, and that's what we're going to be watching. We're going to be watching this live as it goes. And geez, Alan, what did I ever do to you? You look tired, Jeff. What did I ever do to you to make you say bad things? I'm feeling great. I'm feeling young. I'm feeling fresh. You know, I don't know. I'm sorry for looking like crap, I guess. Oh, well. Anyway, yes. We are going to be watching the trial for as long as I can, probably up until the lunch break, and then we'll probably pick it up a little bit more tomorrow and finish it off. Because they were doing the hearing yesterday. I thought about doing that, but then Maritime Monday is already locked in, so that's one thing we couldn't do. But then I went back to watch it, and the video, I mean, it was absolutely horrific audio. And the second that I got there, I listened to this really, really bad audio, and then they instantly privated it and they ripped. I guess the audio was so horrifically bad that even Law and Crime couldn't stand it. So they ripped it. They just pulled it. And there's only about 32 minutes and then about 28 of that was actual hearing time that's salvageable from Detective Moretti's appearance on the stand yesterday. Let me move my camera over here a little bit. What can we do? We just gotta roll with the law and cuck punches. So they're just so you can see what's going on backstage here. We do have this. Let me embiggen it as much as possible here. Let me full screen this thing here for you. Right. Why are we? I guess we can't full screen it until it starts. So anyway, this is what we're looking at here right now. We're still waiting. It's supposed to start 7 minutes ago, but we know court never starts on time. I'm monitoring it. I'm watching it, and let's kind of see how small we can make this. Normally, we want to make the videos as big as possible, but today we want to make it as small as possible. Jack it up, man. That doesn't help us at all, does it? I guess that's about, there you go. That's about as small as we're going to get it. So we'll keep it there. I wish there was a way to layer that. Is there a way to no, there's not a way to layer that. That's a default thing. All right. We're just going to be hanging out here and chilling. Meanwhile, the dogs are over here just kind of licking each other's faces and driving me nuts. So, all right, what we're going to be doing while we're waiting for this to happen, or while we wait for the cameras to go live, while we wait for something to happen in the courtroom, which is when I'm going to go grab me a beverage glass from right across the way, we're just going to be talking about what I wanted to talk about anyway. We were supposed to be having a guest today, but he is he's watching the hearing. I can't think of a better place to watch the hearing than right here. So, hey, Bryson, if you're watching, get on in here, buddy. He didn't think I was going to be watching. I didn't think I was going to be watching the trial. They didn't post this up until just a couple of minutes before. So anyway, that's where we are. we're here. We will have Bryson on. Bryson Boom Paul, who was the person there on Twitter that was running the poll to see who the best YNW Melly trial recap channel on YouTube was. And due to your support and love, I won. I was victorious. That's right. You helped make Lawrax become voted the number one YNW Melly recap trial on YouTube. Yeah, ironic. It was a hearing that couldn't be heard. And some people said there was a hot mic where somebody was ripping into Prosecutor Boutros. I don't know what was said because that part is gone forever. But let's talk a little bit about what led up to this hearing. There was a bunch of submissions that were made, and I want to kind of go over some of the highlights of those. Basically, what they were is, well, one of them we don't really need. One of them we'll talk about if we get time. Because what are we doing? All right, we'll still keep watching that. One of the things was the state has new discovery. In other words, it's new evidence that they've submitted in advance of the hearing that was held yesterday. Yesterday, they had Boutros on the stand, Prosecutor Boutros. She was the one that ratted Moretti out, who made all of these allegations that, she didn't know what was happening. She said she would never, ever, ever work with him ever again. She could never work with him because of what he said when he solicited another police officer to falsify a statement to say he was somewhere where he wasn't. Statements like that. Well, they submitted some evidence on her, and they submitted some additional evidence. Well, it's just new evidence because they were going to be bringing her in as a witness. The defense was going to be bringing her in as a witness. And so they said, well, here's some evidence we have about her that we've uncovered. Hey, Danielle, thank you for loving the hat. All right, so let's, while we're waiting for court action, let's bring this screen up here. We'll stop that screen. I'll keep an eye on it. And bring up this motion. It doesn't show the evidence. It just tells what the evidence what the evidence is. The new items of evidence are. Share screen. Window. Right. I guess we need the standard old view for this one, don't we? Right. That's the standard old view. Why does that look wonky? That looks wonky. It looks smaller than normal. That's what he said. Whatever. Right, here we go. This is hang on, just let me bring this so I can see court cam, see what that's doing. And again, same rules always apply. We've got doggo cam lined up if and when we get to that hallmark moment and unlock the doggo cam achievement. I'll have to go chase them down. They seem to be out of the room at the moment. But State of Florida v. Jamel M. Demmons, this is the state's supplementary discovery. Discovery is what they call turning over evidence for the prosecution, turning over evidence to the defense, etc. And this is what they're doing. They're saying, okay, we have new additional evidence to turn over to you. And what they are is 3 subpoenas that were signed by Michelle Boutros for Detective Moretti on October 17th, 2023, 5 days after the incident alleged by Boutros. So I think that, that should have been 22. I believe that's a typo. That should have been a typo. So they've got these 3 subpoenas, and also they've got screenshots. These are the screenshots that they submitted as additional evidence. Screenshot number 1 from 10/12/2022. At 10:18 a.m., Detective Moretti initiates contact with ASA, that's Assistant State's Attorney Boutros, letting her know he arrived for the statement. Let me see which one is better here. There's an order that works better. It's 11:20 at 9 a.m. All right. Let me see. Yeah, I guess this is probably the better one to go for. All right, we don't need that one. So we've got this first screenshot was Detective Moretti initiating contact with Boutros saying, I've arrived for the statement, and Boutros says, I'll be there in 5. And then that was the day of the incident. And then 2 days after this incident that's been alleged to have occurred, on 10/14/2022 at 10:23 a.m., Boutros initiates contact with Detective Moretti, asking if he has had any luck getting into the phone. And so this incident they're talking about, this is the incident of Moretti reportedly serving this illegal search warrant on YNW Melly's mother's phone, forcibly removing the phone from her hand and taking it away, which so horrified Prosecutor Boutros that she ratted him out and said he did all of these horrible things, including soliciting another police officer from the other jurisdiction, Officer Gurrell, to state that he was in the room when he clearly wasn't at the time it happened. So 2 days later, she's asking him, because remember, she said this was all a horrible thing and the evidence should be tainted. He did all these bad things. Judges here. Let's we'll get back to that as soon as we can. Share the court screen and share away. Oh yes, we have great audio again. I'm going to boost this up 600%. And that's it. That's as good as we get. They don't know if Raven Liberty's. I'm sure my audio is way louder than the court, but there's not a damn thing I can do about it. They don't know where Raven Liberty is. Oh, hey, we've got audio.
And that is why, quite candidly, it makes what I'm about to say even more difficult.
Uh-oh.
When you are in a courtroom like this, and you have prosecutors that you're dealing with, I've found out through the ages, the years, I should say, that 2 things happen. One is you start disliking those people that are sitting at that other table more and more. Or you start building up almost a camaraderie because you're in this together, and you find likeness and fondness. I can be honest and say, on an individual level, I find myself to be fond of all 3 prosecutors here, and I mean that sincerely.
Oh, don't fondle the prosecutors. What happened?
And what I'm doing right now, Your Honor, is renewing our motion to dismiss. The title of it was based upon prosecutorial misconduct, double jeopardy, bias. I have my phone here with the exact title. Give me 2 seconds.
Wow, what happened yesterday? This must be about something horrible that was said about the witnesses.
Government and prosecutorial misconduct in violation of defendant's due process rights. It was filed on 9/26/2023.
Okay, this was a long time.
Renewing it is, and I also want to renew the motion that we had filed on recusing the entire state attorney's office. Both of those motions were predicated on the fact that we were saying that there was institutional.
Counsel, this is the way we handle it, all right? You want to file a motion, you file a motion. I'm not just tennis, just re-noticing or saying you're going to rehear or, refile your motion when the state doesn't have a copy of whatever you're asking for. I mean, it's notice and opportunity to be heard. So they need notice of what you're doing, and it needs to be set down for hearing. All right?
Fair enough.
Okay, so he's saying he wants to renew the motion to get rid of all the prosecutors, and he wants to renew the motion to dismiss the charges. And the judge says, well, don't talk about it, do it.
All right, you ready?
Yes, this is live, Megan.
Judge, yesterday during the lunch recess before we broke, I did go through all the remaining search warrants. They're issued here, made the corrections that were necessary, so I believe the remaining search warrants 3 through 13 should all be coming in, so I don't have
Want to take care of that now, or you're just doing?
I've already proposed to the clerk, we've already put 3 already there, and it's his suggestion that one at a time I bring them up so that they don't get confused.
That's fine. That's fine.
How's the audio, guys? How much louder am I than the court? This is as good as it's going to get.
So Judge, the third warrant would be court exhibit number 3. Is that correct?
He's saying yes.
I think it's C, when we A, B, C.
C, but it will be entered as number 3 as a court exhibit. 3 marks.
So counsel, while we're waiting for Detective Moretti, my understanding is there was an email that was sent out regarding juror 688. Anna Netlin. I didn't know if you all responded to this.
I don't know if we did, but we have no objection to, excuse me.
No objection to the item.
All right, so based on her letter, I guess, with the new dates.
All right, I'm going to run some tests here to see how really out of balance it is and do what I can to lower my microphone so you can all raise your stuff.
So I know you sent written some responses back.
I was advised that we did not respond to 1 or 2 of them, just that one. Just that one? Okay.
So you'll keep all of these.
Okay.
Yes, sir.
Talk, Judge. Say something so we can hear what's going on.
You want to have a seat? Detective, we swore you in yesterday, right?
Yes, sir.
And you understand you remain under oath as a continuation of the motion to suppress hearing for that?
Yes, sir.
Counsel, if you're ready, you may proceed.
Let me show you what this is.
Okay, is this, I didn't see, I was looking at my phone. Is this Detective Moretti?
Exhibit 3, C, and then put in as court exhibit number 3.
Yes, this is the search warrant and affidavit for the iCloud related to the phone, the target phone.
I can't hear you.
It is the affidavit and search warrant.
Oh, it is Detective Moretti.
Related to the target phone in this case.
What was that part?
7772-713-9807.
All right, I'm turning my own phone on here so I can hear what it sounds like coming through.
Let's go to the second page of the affidavit.
Okay, I'm going to turn my microphone way down.
And that has that familiar language in there about segregating it, or as it's written here. Once your applicant has obtained those records, your applicant and other agents authorized to execute the warrant or to assist therein shall conduct an actual search of the items obtained from the out-of-state electronic communication services or remote computing service provider in order to sort the evidence of the crimes articulated below and specifically sought herein, which may be intermingled with innocent or innocuous documents or records.
Correct.
How did you do that?
When you go through, when you evaluate the evidence in the case, you determine, because it's your case, you should know what's going on in it. So you can determine what's applicable to the case and which is not.
Okay, so wouldn't that be exactly the same as if you just said, I want all these records and I will just determine what I want to use?
No, sir. Why? Because, I mean, some of the evidence that comes in, we can't, to a certain extent, we can't control what everything Apple is going to give us. We give them a warrant, we give them what we're looking for. But
Okay, my microphone's at 27%. Let me see how this.
Unusable data. And so we discard it. We still save it as a part of discovery. So we're not trying to, hide anything from the defense. But we give them, but we only use what is applicable to our case. Anything else is there, but we're not using it.
Okay, and so therefore there would be 2 sets of records that you would have. One would be with the gone through documents and only the ones that you believe are applicable. That would be in one set of records, and then there would be all the records would be in another set.
what happens is when the actual original documents come in from Apple, it comes in as a zip file. It's a very strenuous process. Downloading it from one, you have to use Cleopatra, which is a software type decrypting platform. After you decrypt it, it's a zip file. You have to unzip it. So that right there is your data. That file remains the same. When I turn it over to Discovery, that is what I turn over because I give everything to the state. So there's no accusations of
My microphone is now at 14%.
Then there's the working file, what I work with. Then from from what I'm working with, and if there's any evidence obtained, that is what then I give to the state as well.
Okay, so then there's actually three. You have all the data, then you have the working data, and then you have what I'm turning over to the state data.
No, it's two files. We have the original, with what we download, from the extraction. Then we have a working copy. That working copy is
I think we're getting somewhere. The microphone is now at 10% and far away from me.
We work off of what we take out of what we use.
Okay, where is that working copy?
It's all in the file when we turn it over.
Who did you turn it over to?
It's turned over to the state.
Okay, so you turned over both sets to the
No,
state.
we turn over one file, then whatever is what we use, it's annotated in the documents, the reports, the search warrants.
I'm going to be candid. I'm a little confused. Are there two sets of records or one set?
It comes back. It's one set, but we were able to. The report will tell the state what is applicable, what is not.
Okay, so it's not actually ever segregated. It is just delineated which stuff you're going to use and which stuff you're not going to use.
Correct, sir.
Okay. Now, were you the person that did this, or was somebody in your team that did this?
No, sir. It was me.
And he's being questioned about all the steps and all the processes involved in serving the search warrant on YNW Melly's mother. That's what they're limited to. They're not talking about the evidence in this trial, in the murder trial. And
when you gave it to the state, is there notations on the records themselves, or is it just by memo to the state?
It's within the final work product. When we write our final report to the state, it identifies what we used from Apple. There's no extra memo for filings like that. My report will say, on such and such date, we received a response from Apple. This is what was applicable. It's all embedded within the report.
In which report?
My final report we give to the state.
Okay, is that your final police report, or is this an internal memo?
It's the final police report. Whatever evidence that we got from this, it's annotated in there.
In the final report, yes. And when did you do this? First of all, when did you get the material from Apple?
I would have to, see the file from the state. I don't have that access to you right now.
Do you immediately then take this stuff and work on it, or does it sit? How does that work?
Most of the time, let's see, I can give you an estimate. This warrant was submitted on November 14th. Apple's usual response probably about a month, usually, give or take. So if I had to make a very raw estimate, it's sometime in December, maybe January at the most. So you have a question?
Now, because the way you did it, as far as keeping all the records together and just annotating what you're going to use, there were innocent or innocuous documents or records that were sent to the state, correct?
I don't know if anything innocuous or that I can't say, sir.
Because you did not use everything that was in these records.
Correct, sir.
And because some of these records have no relevancy to the case.
Yes, that is correct, sir.
And so therefore, they were innocent or not innocuous.
Correct, sir.
But they still went to the state.
Yes, sir.
Okay. And then they ended up going to us through discovery.
Correct, sir.
Okay. And nowhere along the line do we know until we read your final report what you decided to use as opposed to what you determined to be innocent or innocuous.
That is fair, sir.
Okay. So there may be things that are not innocent and maybe not innocuous that you decided not to use, but if we were looking at your report, we would think that they were in the innocent or innocuous because they're not being used by you.
Correct.
Okay, so we would be confused by them.
I can't testify to.
Well, they would be all lumped together.
Yes.
The innocent and the innocuous, along with what you determined to be irrelevant or altogether or unusable.
Yeah, I just believe in turning everything over because I don't want to be accused of withholding exculpatory evidence.
Oh, he doesn't want to be accused of not turning over exculpatory evidence. Well, maybe he's already been accused of
For
that.
this affidavit, what information did you get from was based upon any other information that you had received from any other search warrants?
Can you expand upon that question? You mean in the public cause?
Oh, god dang.
What specifically are you referring to in the probable cause portion?
Well, you used as part of the probable cause information you got from the first search warrant dealing with the cell site warrant, so, correct?
Yes, the cell site warrant is referenced in here. Yes, sir.
Okay, what was that information you got?
I think it's on probably the second page of the probable cause affidavit. It says a search warrant was obtained on the cell sites used by Demons, Withers, Williams, and Thomas. Let's see, it was determined that Withers did proceed to the residence at 18521. It shows the time he arrived in Sunset Lakes. It shows then the cell site data places Demons and the other four out there on US 27 at a specific time between 353, 406. Then time they moving back as well.
So that's what you got from the first search warrant?
Yes, sir.
Okay. Anything else from any other search warrant went into this?
Just want to make sure. No, I think that was about it, sir.
1 second.
Hey, Hayden, why aren't you sleeping, brother? Welcome. Welcome to Late Night Chat.
Did you annotate in your report what was relevant and what was innocuous?
No, sir.
Did you just annotate what was relevant or just say I got this from such and such a search?
Correct.
The latter part.
The latter part. This is a search warrant was issued in regards to this case. This is the information I obtained from said search warrant.
Okay. So that would be the ultimate sorting that you did pursuant to that warrant.
Yes, sir.
I have no further questions.
All right. Now let's hear from the prosecutors.
Thank you. Just so I can clarify, your warrant actually contains a separate section for search to be conducted by law enforcement,
Yes, sir.
and that's kind of where you specify the areas that you're looking for.
Yes, sir.
The purpose of the search warrant was to get the iPhone back up from the phone that belonged to Mr. Demons because you had determined that was near the crime scene, correct?
Correct, sir.
Your report, do you summarize, first of all, when you went through the data, you had to essentially look at everything to determine whether it was relevant to the investigation or not.
Correct.
And if it was not relevant to the investigation, you, in essence, put it aside because you knew you weren't going to be using that information.
I just disregarded it.
Does your report reflect what you did find to be relevant and useful from that return?
Yes, sir.
And that's spelled out, or not spelled out, but that's enumerated in your location report.
Yes.
Yeah, they don't know where Raven is or whether she'll be in court today.
Not on this one.
Thank you. So want to move to the next? Would we be same order, number 4?
While he's asking the questions, let's do the super chats here. John Williams says, "Congrats to the Law Racks on being crowned best Melly coverage. Here's something towards releasing the hounds. Thank you so much." And Aaron Hack says, "I will second that." John Williams, thank you for the $5 super chat. Great to have you guys here. We'll continue to, if the super chats come in, we'll flash them up on the screen and then we'll read them when there's a little lull in the trial here. And what they're doing is they're making a series of motions. They're making a bunch of motions. They're trying to burn through as many of these as possible. And Detective Moretti is a witness for most of these motions, apparently. So he's going to be here probably for the rest of the day.
Number 3.
And I'm going to take about 5 steps over that way and grab myself a beverage glass. I shall return. You don't need to see what's going to happen if I stand up. So
Let me show you what has been marked as Drive E, as Court's Exhibit D, that will ultimately become 4. I don't think there's any objection.
No, there's no objection.
It will be admitted.
This is the search warrant and affidavit for the Snapchat account of Melly.Montana.
Melly.Montana. Is that like Hannah.Montana? Oh. Melly looks good in orange.
Now, in your affidavit,
Hey, Renee Miet.
where is Mr. Demons mentioned?
Hey, Onawal, I'm glad YouTube told you I was on, because I am. OJ's not in Florida. OJ's in Vegas.
So, what do you say about him? That affidavit?
He used to be in Florida, but I guess he decided the real killers moved to Vegas, and then he went there, and he even went to jail apparently to try to went to prison to try to find the real killers in Vegas.
By Demons, Weathers, Williams, and Thomas. It was determined that Weathers did proceed to his residence at 18521, the residence, at said location on 349. This was also confirmed by the video that they gave to Sunset Lakes. The cell site warrant for the cell phones of Demons and Thomas revealed they traveled north on 84 towards Pine Boulevard, then turned west on Pine Boulevard. But video evidence shows that. The cell phone records will show that Demons was mobile from 320 to 403 on 1026. This was consistent with the video. But the CDR states that the Demons was outside his vehicle. The record stated outdoor stationary. At the crime scene, it has again at 404. Demons was mobile on 27. And it goes on. The evidence also corroborates with historical cell site issue in this case. It was revealed that other methods of communication weren't used as a CDR. Called detail records for Demons was.
Let's stop right there. Says it also revealed that other methods of communications were in use as the CDR. What other methods of communication?
On when we get a cell site report, called detail records, the call detail records that we get from the search warrant from T-Mobile comes in. There's 3 different responses that they give us. They give us the CDR, the call detail records with cell sites. Then there is a report called a data report. So anytime the phone is using data, you know, it's annotated in there, then the timing advance information. So it's 3 different reports, but the data report shows that the phone was using data, you know, at that time. And so we know that there was something going on with the phone, some sort of communications. The phone was in use, but we don't know what, because the data report doesn't tell us what's specifically being used. It just tells us that data is being utilized.
So you have no idea whether Snapchat is being used?
No, don't forget for the Snapchat, the reason that this warrant was based upon what Dontavius Withers originally told us, which was a recorded conversation, that they pulled off the road on I-75, so Mr. Demons could utilize the bathroom.
So you learned that was false?
We did learn that was false, yes.
Okay. You knew that was false at the time of this?
No, I did not.
Okay, so the only thing was Mr. Withers saying that.
Okay, so
Mr.
now
Demons had
this isn't the
Snapchat.
search warrant
Okay.
issue anymore. Now they're talking about things going
Should be.
on in this trial, motions relating to
William
this
Withers
trial.
stated via recording statement he was communicating with Demons via Snapchat on the night in question, just prior to the incident. The username for Demons Snapchat account was identified Melly, Montana by Withers and Chris Thomas Sr., father deceased.
That is true, Sheila.
Now,
That's why he went to jail in Vegas. Look for the real killers.
This was submitted on the 6th day of December.
No, but what period of time were you asking for
Oh,
Snapchat?
I'm sorry. 10/1 to 11/25.
10/1 to 11/25, 2 months, basically.
Yes,
Okay. Where you only had knowledge of one possible Snapchat, correct?
correct.
And it was only on the night of the morning of the killings, correct? You had no knowledge whatsoever that there was any Snapchat used by Mr. Demons' phone whatsoever before that time or after that time, correct?
Correct.
And you artificially or arbitrarily just decided on October 1st and November 25th.
Very quick
There's
summary.
no magic to those.
He's apparently testifying regarding various motions to dismiss or suppress evidence.
10/1 to 11/25. Why specifically, when I wrote 11/25, I can't say for certain.
Why did you write 10/1?
Well, beginning of the month, because the homicide happened on 10/26. So always going to the beginning of the month. So I think it basically looked like I was just going for 2 months of communications.
But why?
No reason, sir. Thank you.
He was asking for 2 months worth of communications for no reason.
Any cost this one?
I'm sorry, I wasn't sure you're done, I didn't hear you were telling the witness. Detective Moretti, you've done numerous warrants to social media accounts before.
Yes, sir.
In your training experience, are date ranges requested in order to establish who the primary user of the account is?
Yes, sir.
Is it sometimes argued or alleged that other people use or have access to accounts?
Yes, sir.
And one thing that you would want to know is if someone is alleged to have used an account, that they are in fact the primary user of the account who is in control of it, both before and after the time period in question.
Yes, sir. We would call that history of life.
History of pattern of life?
Pattern of life.
Thank you. Nothing further.
That's either a man or a very handsome lesbian.
No, sir.
Did you think of it until Mr. Griffiths just told you?
No, sir.
Wow, that was short. All right.
Conclude this warrant. We're ready to proceed to the next warrant, number 5.
So going to motion number 5. And while they're doing that, Easy 007, thank you so much for the £5 super chat. How much of the prosecution misdeeds will even be heard by the jury, if any? Well, they can decide whether they are actual misdeeds or not. And if they are, probably not a lot.
Affidavits and search warrants.
Directly.
And some of them, the exhibits that I attached to the motions were missing a page or so. So when looking at this, the ones that are being put as court exhibits, those are the true copies. If there's any inconsistencies, I would tell the court to rely on the ones that are going with evidence.
Understood. And Ms. Griffin, there was no objection to any of these.
Correct, that's what we said. Yes, Your Honor. That's
So
what we
they'll all be
said.
coming in whenever it's offered.
I'd like to offer number 5.
It's admitted.
He just annoys me with this, with that little hangdog expression on his face.
Search warrant will refer to this number 5. It is a search warrant for, what you have it in front of you.
Yes, sir. It's a search warrant and affidavit for a geofence warrant through Google.
A what?
A geofence warrant.
What is a geofence?
Geofence is it's a type of warrant in which we put a virtual perimeter around a known location. And then we set it to Google, and then Google in return will return with devices, anonymized devices in that area. This is it's very accurate. It's been
So
used
think
in law
about that.
enforcement
The
for
police,
quite some time.
anyone in law
It was,
enforcement can just send an affidavit or a warrant to Google and say, hey, give me this person's location. Or give me this area, all the cell phone numbers in this one area.
It prevents from a broad overreach by law enforcement. When they give us back the information, everything is anonymized. We don't know what the actual devices are, or who the people are. We have to filter through it. It's a 4-step process. And finally, at the end of the 4th step is when they will unmask the anonymized number. In this particular case, though, there was no devices out there.
What does that mean?
I'm sorry.
Does that mean that nothing was seized under this warrant?
Basically, yes, sir. It shows that we get a geofence warrant, but the significance of it was that there was no devices were detected in that area during the time frame that I requested. I requested a time frame of 3:50 a.m. through 4:35 a.m. And the response was that there was no devices out there.
Where was there?
The crime scene on Pembroke Road and US 27.
So there were no devices out there?
No, Danielle, there is no jury here. This is all just motions out of court.
Geofence warrant is it mostly focuses on Android devices. However,
They made a motion to get all of
Apple
these
devices
cell phones that were in
Android
the
devices
area
out,
of the
Google,
murder
location data
scene
turned on,
at
then
around the time of 3:30 to 5, whatever he said, and there were none there.
The geofence, the virtual perimeter around the crime scene.
Hey, did you know what kind of phone you were dealing with?
Yes, I knew that the defendants in this case had Apple phones.
Okay, so you said it works better for Android.
It works better for Android, but doesn't mean that we're always.
Danielle
gonna
says
have
release the
Android.
hounds. That will happen $85 from now.
Capture Apple devices using Android applications, which the most common Android application is Google searches.
But you may not.
You may or may not, and keep in mind, like I previously stated, Google goes to great lengths to protect the accounts. That's why what it comes back to us anonymized, meaning it's a unique number that only Google knows, and they only keep that for a short period of time, and then they wipe the number.
So based upon what you got from this, we do not know whether that phone was or was not within this geofence that you spoke about.
No, the response and what I got from this is that there was no devices detected in that virtual perimeter.
Right, but because it's an Apple, not an Android, it won't necessarily be detected. So therefore, we don't know.
Well, you have to understand how the Apple device is set up. If it's set up with if there's a Google account and the location data for that Google account is set up in that Apple device, then yes, you can be picked up.
Now, you explained all that in the warrant.
Wow, that's what happens when good browsers go bad. Hang tight here. For some reason, wow. There we go. Bringing this on up. Maybe that was weird for some reason. Edge just decided to shut down.
If you look at the applicant's opinions, you start reading it
we're
there.
back.
I know that
wild.
Google is an electronic communication service provided by Google Plus Photos, and it goes into there. And it actually goes into the research behind
Hang
it.
on,
You
we're
know,
still
the
working out
Gartner
ye olde
study.
bugs here.
You know, so
There.
it
We should all
does.
be-
Where's the Gartner study?
It's the second paragraph. So when you go to applicant's opinions,
There.
this is regarding Google Inc. Okay, then you go to the next page, based on my experience. I know most people in today's society.
All right.
Uh,
Sorry about
cell
that.
phones
Just
know how
had
to
a
use to communicate electronically.
had a
The next
browser
paragraph,
crash.
in a February 2018 study, Gartner Research Company based in the United States determined approximately 99.9% of all smartphones.
But can I just object that that's a-
Oh, now I got to bring up the volume, right? Shit, I got to do all this again. Sorry.
Just think, it's in the affidavit.
Sorry for shouting.
Thank you, sir.
Okay, microphone is still at 10%. That's good.
What experience did you write in here?
Oh, get out. Okay, that's not me good. That's a them problem. Live stream is offline. Well, I'm so glad I hurried to get back just in time for them to go offline. Right. So we'll continue where we left off. For those of you that are just joining, we.
You know,
never mind.
I've been through several cell phone investigation classes. I've been through digital forensic examinations, cell phone investigations, cell site classes.
And that's all written in this affidavit?
No, sir, it is not.
Okay. Why not?
It'd be no reason, sir. Just be an oversight on my behalf, I guess.
Then you didn't put your credentials as to why you know these things in this affidavit.
Just an oversight.
Yes, sir. I mean, I have all the certificates and training and everything else.
Okay, but you just left it out.
Yes, sir.
Since you're based upon my experience.
All right, there we go. How's that for volume?
Google account, Google will request an associated phone number from the user to assist in recovery if a password is forgotten or for security. How do you know that?
I am familiar with Android devices. I myself use Google, use Gmail, so I have actually set up my own accounts. It's two-factor authentication, so you can either use another email or a cell phone number to reset your account.
Okay, and you put that in there.
No, sir.
There again, we're back to where we were. 600% court audio, 10% my volume. All right, let's.
Now, in this affidavit, you also have information that you got from the search of the first search warrant for cell site.
Yes, sir.
So these are affidavits about the search warrants that he
So
was
any other
seeking
search
for
warrant?
evidence in the murder case.
This was done in January 2019. References the video evidence from the hospital. Talks about the shell casing recovered from the scene. Match what was in the vehicle. So the forensic ballistics. References the Dr. McDougall's findings. That's it, sir. That's it.
It's not you, Vicky. It's them.
I think the question though was, what did you get from the first search warrant?
The first search warrant I got was the, very first search warrant was the vehicle. I think the second search warrant was the.
The one that we're talking, we're
Yes.
calling the first.
Okay, I'm sorry. The,
No, you don't need to be sorry for that. You're fine.
The second search warrant, or first search warrant, is the T-Mobile one. That's what was referenced in here, the cell sites.
No further questions?
Ross?
Just so we can have kind of a clear understanding, I'm gonna use a crude explanation, but the geofence is essentially a modern day tower, correct?
Yeah, in essence, it is a modern day tower dump. However, I believe, in my opinion, that the Google goes to greater lengths of protecting an individual's privacy more than when a tower dump. Because when we execute a tower dump.
Speaking of power dumps,
we get exactly the cell phone numbers of the targets.
And geofences, because they're a Google geofence in this case, it's limited to Android devices or devices using Android or Google-based software that are either connected to a cellular network or a data network.
Correct.
So if it's not using any of those software, or if it's not connected to the network, at least in theory, Google is not detecting or picking up that data.
Correct.
And you did this over, you drew or created a cordoned off area basically around the crime scene to see if there were any of those types of devices located at or near the crime scene at the time of the crime.
Correct.
You redirect?
Just very briefly. If Mr. Demons had a Google account, then it would have shown up in that geofence, correct?
No.
But you said that they can detect the Google account.
Well, what Fulton said was, if they have a Google account with location service turned on, we know that after post the search warrant they did on the defendant's Gmail account, knew his location services was turned on.
So when you sought this search warrant, it was a hit or miss whether you get it.
Absolutely.
Okay. So there was not probable cause that you would actually find something there. This was a.
It actually calls for a legal conclusion.
You were using this as an investigative tool.
It is investigative tool.
Thank you.
All done, so can we go on to the next one? The motion to suppress number 6.
so again, let me bring up the chat here. Totally not a Russian bot says, I'm a bit lost. Shouldn't there be actual phone expert testifying to this? But they're not testifying as to the truthfulness or the accuracy of what's included in the evidence. They're arguing about whether or not that evidence should be suppressed and not allowed to be brought up at trial. And to make those arguments, they're talking to the people that swore the affidavits to collect those evidence as to how, when, where, why, and the methods for requesting the information or the evidence that was obtained through that search warrant affidavit. And he is responsible for a great number of the search warrants and the affidavits relating to the search warrants in the case. So he's on the stand to talk about how the background and all the information related to how they obtained these search warrants, what the basis for the search warrants were, et cetera, et cetera. And this is just another motion to suppress some more evidence. And while he's looking at that, RB's been a member for 12 months. Woohoo! Your membership's my birthday. And Melly, what a day. Cheers. Cheers to you, brother. Happy birthday. And thank you for sharing it with me.
As it pertains to my clients.
Okay, then it would be three Facebook accounts, Jamel.Demons, Mookie.Guwap.9, and YNW Melly772.
In this affidavit, what is your basis for the Facebook account? What do you state? Why it's relevant?
Oops, that was me trying to move the closed captioning up.
If we start on starting the fifth page,
Gotcha,
probable
bitch.
cause. Towards the bottom, I
Come
started
on.
getting into online searches for public individual profiles. On Facebook showed multiple images. Facebook shows multiple individuals down through law enforcement interviews. As Jamal Demons for the Facebook profile, Jamal.Demons. Mookie Buwa, YNW Melly 772.
Mookie
Profile
Doo-Wop.
associated with
Jesus,
Jamal
people
Demons,
get new names.
musical endeavors and used to advertise public appearances, performance, and music. And that's when I started going into all of that.
Why, there's not one reference in here, is there, to why there would be any evidence of the murder, of the killings of those there?
No, sir.
Then why were you seeking Facebook, or was it just you were seeking everything you could associated with Mr. Devins?
No, sir. We know that there was a lot of communications that night. And we know it was done, over social media platforms. So I had to see all forms of communications.
Okay, so he knows that Melly's
That's why we
doing,
did the search warrants for these
he's
accounts.
communicating through social media. So these are affidavits to get his social media records, Facebook, Instagram, etc.
So in any investigation, we do not know what Facebook is going to give us, or any social media outlet.
No, that's not what I'm asking. I'm asking, when you wrote the affidavit, you had no information or evidence that Facebook would contain any information valuable to you in the investigation.
No, just that the social media platforms were in use, but to what extent the conversations were, I do not know.
And what period of time did you ask for the search warrant to be for?
I don't like that. He just has that
There is
hangdog
no,
look that annoys me.
This one, sir.
So this goes all the way back to the beginning of his account, doesn't it?
Yes, sir.
How far back did it go?
That I do not know. I would need the actual accounts in front of me to tell you that.
But we're talking a couple of years, correct?
I couldn't answer that, sir.
Why did you need information going back to the beginning of his Facebook account?
So that was purely a administrative error on my behalf. I should have put a date time in there.
An administrative error on his behalf.
That's right now.
The question, if you didn't hear it, was apparently he sought a search warrant for all of Melly's Facebook communications going back to the beginning of his Facebook account. He said, why did you ask for him to go all the way back to the beginning of his account? He said, oh, it was an administrative error.
It comes on.
He should have put a date, but he forgot, or he made a mistake.
It's the same thing. It comes in through we have to download a zip file. It comes in, and we have to decrypt it and download it.
And who did that?
I do, sir.
Okay, by yourself or with others?
Myself.
Okay. And then you segregated the innocuous material from material that was relevant?
I just write obviously, yes, there is separation, but when I turn it over to the state, I give the state everything because I don't want to be accused of withholding exculpatory evidence. But what's in my report, what we use is what's annotated in my report.
Okay, but there, again, and I will be asking you this again.
Yes, I understand.
Again, there is no separate file.
I'm not seeing that in the least.
One of all the material.
Don't waste your time, Pete.
Whether relevant to the investigation or going to be relevant to the investigation, but a file that it does not have the innocent or innocuous copy.
Correct.
Okay, so we only have one file and then your police report.
Yes, sir.
Now, you didn't tell the magistrate that was signing this that that's what you were going to do.
It's overreaching. They're looking for things that may point to evidence of crime. And he's going back and asking for the evidence going all the way back to the beginning of his Facebook, which, it's overreaching on the part of the state is what they're going to be arguing. So saying anything that was found before a certain date should be suppressed and rejected, whatnot. So yeah, you can't just go, oh, we want every single piece of communication this guy's ever given since the day he was born. That's what they call a fishing expedition. It's not targeted at a specific investigation or finding some sort of exactly.
Communication when used as a CDR called detailed records made reference to service type of data only. So we know that there was data being used at that night, just not what data.
That was it.
Yes.
Thank you.
Yes.
Round one, see a scowl. And I can pick up a scowl in a hurry.
Lawyers are starting to scowl already. Speaking of scowling, the dog and a member for 3 months says, "Hey Jeff, unrelated question. Did you know they don't teach Edgar Allan Poe in school?" Well, that sucks. Nephew-in-law
Clear this up.
didn't even know who that was.
We will be able to.
F public schools. Thank you for being a member for 3 months.
Such a date, I gave an affidavit for a search warrant to Judge so-and-so. The warrant was signed. We received on such and such a date all this material, and I've gone through it all, and we're only using A, B, C, and D.
It doesn't use that exact verbiage, no.
What does it say?
It just says that a search warrant was issued, and then this is what the result, this is what our findings were, this is what was applicable.
Nothing further.
Any questions?
I'm still trying to figure out if this is a man or a handsome lesbian.
Search to be conducted by law enforcement that specifies with more particularity what it was you're looking for.
Yes, sir.
There are 4 items listed. 3 of them concern essentially the identity of who is using the account.
Yes, sir.
And then item 3, communications between suspects Jamel Demons and Cortland Henry.
Yes.
So Jamel Demons and Cortland Henry were suspects at the time of this warrant was being issued.
Aaron Hack, the
Correct.
prosecutor is asking the questions right now.
Your affidavit also specifies that the profiles for Jamel.Demons, Muski.Guwap.9, and YNW Melly 772 were public at that point.
Yes, sir.
You were able to see images, basically for his public appearances, pictures that he had taken that had been posted to the account, etc.
Yes, sir, that's called open source.
Right, and among those pictures taken were including him, images where Mr. Henry and Mr. Demons were tagged in photographs and wearing shirts memorializing the deceased in this case.
Correct.
So between the fact that he was posting images after the homicide, depicting at least his in memoriam for the 2 victims in this case, as well as the fact that the call detail records reflected that data was being used on the night of this incident, did you have reason to believe that there were communications or other information relevant to your investigation contained in the Facebook account?
Yes, sir.
In your experience, at this point, you knew that Mr. Demons had used his Snapchat account to communicate that night.
Yes, sir.
Mm-hmm.
In your training experience, individuals who use one social media platform tend to use multiple social media platforms.
Yes, sir.
And given the fact that the defendant had 3 separate accounts that he appeared to be actively using, does that corroborate what
He's
you
the
know
cowardly lion of
experience
detectives.
in fact involved in multiple social media profiles and was using them actively?
Yes, sir.
Well, Flux, now that you're here, you can tell us if that prosecutor guy is a man or just a handsome lesbian.
So all these things
Not that guy.
Mr. Griffiths just said to you, why did you put them in the affidavit?
Because I just feel it was understood.
Oh,
Understood.
Yes, sir. I mean,
Everything that he just
Well,
said
yeah,
about
I mean, the search conducted by law enforcement, that it's in there, all communication with the suspect. We actually identify in the search conducted by law enforcement, the communications, it's specificity towards Demons and Cortland Henry. We put in there that we knew that they had a.
Great, but you did this.
Yes, sir.
When you said we put it.
Oh,
thanks, Flux.
so that, I put in there that the,
I like this prosecutor a lot. I mean, just defend
which is,
a lot.
Used to advertise public appearance. So if it's out there for anyone to look at, that's reference.
But that whole litany that Mr. Griffiths went through, as far as that he was wearing the shirt afterwards, and that he posted it on Facebook, and that because that the Snapchat, but that whole beautiful thing that Mr. Griffiths said.
Melanie,
that's not in there, is it?
you're forgiven. Just don't let it happen again. That's part of the repentance process. Recognizing, feeling remorse, and not doing it again.
No, sir. Thank you.
Briefly, Your Honor.
Go ahead, sir.
If I could turn your attention to.
I see it now, sir. It's on the,
the top of page 6.
yeah,
The information that I discussed during my initial cross review, all that's contained in your affidavit, including on the last page of the affidavit.
yes, sir. That's right there at the top. It says that Jamel
Thank you for that
Devon's
cough.
tag in the photograph
Jesus.
wearing shirts memorialize deceased individuals in this case.
The last page of your affidavit only contains a summary of how the Facebook account is, in short, connected.
Well, they can definitely get cranky with me.
Yes, sir.
Yeah,
Thank you.
if my name is mentioned.
You're done? Thank you.
Don't shit post in my name. Anyway, okay, real quickly here. Medita Finn asks, what are they trying to accomplish today? They're going through motions to suppress evidence, to exclude evidence, to limit evidence. And as I was mentioning, they do that by calling in the person who wrote the affidavit to get that evidence, to talk about how they got the evidence, why they got the evidence, what the scope of their investigation was, et cetera, et cetera. And Moretti just happens to be the guy that's responsible for most or a great deal of the affidavits that served as the basis for the search warrants that collected the evidence they're trying to keep out.
Evidence as court's exhibit.
It's good to see Gene Simmons, Ronnie James Dio, and the hedgehog Ron Jeremy as the court reporter today.
This is for
Good to see her.
the Instagram accounts of the two defendants in this case.
Again, I'm only interested in my findings.
Yes, sir. Yes, sir. This is for the
Michael
Instagram
Burke
account
is
of YNW
Moretti
Melly.
still going to testify? Or, I mean, that's up to the prosecution whether they want to bring him in or not and face the risks.
The time period in this one is from
Other Danielle.
1/18 to 1/15/19. That's what you're looking for records.
Yes, sir.
How did you come up with those dates?
Basically from the time of the homicide and up until the time I wrote the warrant. This warrant was submitted on 23 January, so I did it up till January 15, 2019.
And how did you pick October 1st?
The October 1st is, the month of the homicide, and then I just kept it until up until January.
Yes, but why October 1st as opposed to October 10th?
One of the larger understanding of the pattern of communications of the defendant.
Then why not September 1st?
September 1st would be going backwards.
Right, you said you wanted to see the communication pattern, that's why you went to October 1st. I'm saying, then why didn't you go back to September 1st?
I kept it to the month of the homicide moving forward because I figured the communications post-homicide were more significant than what would happen before the homicide.
Now, you also in this one were going to go through all the information provided, correct?
Yes, sir.
And pull it out. Unfortunately, I have the inevitable task of going. through
Oh, you're just saying that because Nick Starov's not
$180,000.
streaming anything. I know you.
Did you go through each one?
Yes, sir.
And so you went through the 1.4 million approximately lines.
The way that I did it was I was able to extract 20,000 at a time, and then I just able to quickly filter through what was applicable and what was not.
How could you do that? You had a program?
Yeah, how did you
Well,
determine?
I just used Acrobat Pro. It allowed me to take out 20,000 pages at a time, create its own file, and then I'm able to just basically Control F and filter.
Hey, MLS, what's up? No, this is Melly.
The records
YNW Melly trial. Motion hearing.
very quickly. Yes.
How long did it take you to go through the 1.4 million lines of data?
Like I said, I'm using Control F, which is the search function within Acrobat Pro, and I just I started looking for keywords or key communications, and that's how I filtered. Did I look at every single line? No, but but I was able to using keywords, or as I was reviewing it, I would see thread IDs that were significant, and then I would filter through that way. If I see other keywords or individuals of interest, I would filter through that as well.
Okay, what were your keywords?
Well, like I said, any type of thread ID. I'll give you a very common individual he communicated, which was PZ Gambino, which is Patrick Deloach. So I was able to isolate that thread ID and start filtering through all the communications. Anyone else that I saw that he communicated on a regular basis pertaining to guns, drugs. Gang, if you're able to filter through and pick out those keywords in that conversation.
This is a good lesson on why you don't put shit that you do. And again, this is definitely not legal advice, but just know that this is how the police catches people. They just pull all of your communications and search for the stupid shit you text to each other.
I actually was able to extract it and then put it into an Excel spreadsheet, because those conversations were very significant to this case. That one was actually put into an Excel because there was so much communication that I had to isolate it instead of filtering through 20,000 pages at a time.
Even you gave that Excel spreadsheet to the state?
Yes.
Okay. So that's only dealing with this one PZ Gambino?
Yes, sir.
Okay. Did you do it for anybody else?
And no, that was the most significant of all the conversations.
So is it a fair thing to say that of the 1.4 million lines, you did not review all of them?
Not all of them, no.
That isn't fair, or it is fair?
It is fair. I was able to filter through them. I'm not looking at each and every single line. Did I go through all the pages? Yeah. But did I look at each and every single line? No.
Okay. And other than the Patrick Deloach, PZ Gambino thread, nothing else was segregated out, correct?
Some of the conversations with his mother on the morning of the homicide, which they were communicating, that was significant. That was filtered out. I don't think, to the best of my recollection at this time, I don't think I filtered anything else out.
Okay, so when you say filtered out, you
Yes, that's what we were calling him during the first trial.
from the 1.4.
We were calling him John C. McGinley.
And I'm estimating 1.4.
And I know you know that.
We're not disputing that it's up there.
280,000 pages, sounds like a reasonable number.
Okay. So the innocent or innocuous documents or lines or whatever, they are still with the bulk of everything, correct?
Yes, sir.
Okay. They have not been segregated out. Only what you thought was relevant to this prosecution was segregated out, correct?
Correct.
And not all of that, just these two people, his mother's and Patrick Deloach. That doesn't mean there are other things that are not in there, that are in there, that are not also relevant, correct?
Correct.
Okay, but those weren't even segregated out, correct?
Correct.
Now, you were asking for all the data that Facebook had, correct?
The relevance judge, we've moved on to the Instagram warrant. I know he wants to compare it to the other warrant, but it's not relevant for this motion.
Say again, sir?
So you were asking for all the data, correct?
And I explained that, I should have put a date and time frame in there, and I did not, and that was an error on my behalf.
But even during that date, those dates, you were asking for everything that Instagram has, correct?
Well, anything, well, actually, property provided by, Facebook, and then what I was conducting research by law enforcement.
Well, it says here, based upon the totality of the circumstances, this detective is requesting a warrant pertaining to data stored with Facebook, Instagram.
Answer is not saying all, it just says based upon the totality of circumstances, the detective is requesting a warrant pertaining to the status stored with Facebook Inc., which is Instagram. That's not saying all of this. Then when you go into the property provided by Facebook,
Yeah, what you want to be provided by Facebook?
everything that's listed in there between those timeframes, and when I'm conducting a search is for the full items.
Okay. You have, for the property provided by Facebook, is there anything that you thought of that, since you know about Facebook, you live with Facebook?
Yes, sir.
Okay. Is there anything that you know that Facebook would have in their possession that's not listed, that you know?
No, sir.
Okay, so everything that you're asking for is everything that you know or believe that Facebook has on somebody's account.
Yes, sir.
Okay, so the term all is appropriate, isn't it?
I'll concede to that, yes, sir.
What information in this affidavit was gotten from other searches? Search warrant.
The other warrant reference in here is the T-Mobile cell site warrant.
And that's on the second page of your probable cause narrative.
Yes, sir.
Okay. Anything else?
No, sir.
Did you get anything from Snapchat?
I think this warrant was done before Snapchat. When was the Snapchat warrant done?
David's out to court. Thank you so much. Well, if you're leaving, we'll do this right now. Danielle has beat me by 2 months for the monthly membership. Thank you so much. MLS Law. MLS Making Law Simple. David, part of the MLS N. Thanks for stopping by. Yes, this is Melly's lawyer questioning the detective. Absolutely correct, Melstar 83.
You don't see Snapchat in there?
No, sir.
Okay. You're good.
Thanks.
No other questions?
Thank you. Ross?
Okay, Prosecutor Katie Lang is going to be coming up to the stand.
Regards to Facebook. At the time of this issuance of this warrant, Facebook owned Instagram, correct?
Correct.
And they've since rebranded as Meta Platform.
Yes.
So when you're sending a search warrant for Instagram, you have to send it to the parent company or the owner, I guess, of Instagram, Facebook.
Or they will not accept the search warrant.
Also contained in your affidavit, you again reference the fact that data was being used that night.
Yes, sir.
You also referenced that the Instagram account YNW Melly was publicly available and that multiple images of individuals identified through law enforcement as Jamel Emmons were tagged within that account.
Yes.
Page 5 of your affidavit.
Yes, sir.
And that was both before and after the date of the incident.
Yes, sir.
And again, you referenced that individuals who use social media accounts use them for private messaging. And given the fact that you both before and after the homicides, it's apparent from the public facing that this account was being utilized before and after the time of the killings.
Yes, sir.
No further questions?
Thank you. So, you going on?
Sorry, step on his foot. Okay.
have another foot.
Oh, that's not Katie Lang.
And I would charge him with battery myself.
I think he was.
Aggravated battery.
You're going on to the next.
Okay, they're between motions here now, so we'll stop with Joe Choi. Thank you so much for the 10 pounds. Have some pounds for doggy treats, Jeff. Joe Choi with a 10-pound super chat is now the vice racks of the day so far until she's dethroned by a larger super chat. Danielle, who's been a member for 8 months, feels a lot longer than 8 months, but I'll celebrate my milestone anyway. Thank you for supporting me for 8 months. And Ginger, King Ginger 333, member for 9 months, watching this on the beaches of Cocoa Beach, Florida. Wow, I'm not.
Let me show you what we have as the 8th search warrant affidavit combination.
Yeah, this is the 8th search warrant affidavit.
As court's exhibit. Recognize it.
This was a real-time search warrant with cell phone where we actively ping a phone for location.
That is true.
And what was the purpose of this?
We this was very close to before grand jury, and we started to monitor his location data in case if he became arrested, if he became indicted and he was indicted, and then we could easily arrest him.
You got 480 concurrent viewers and 292 likes. Like 50% of you, 200 of you haven't done your job. If you're watching this, just while they're not talking about much important, reach down there and smack that like button, please. I would appreciate it. If you're not subscribed to the channel,
live tracking.
give me a crack. Come on. Just take a risk. Hit that subscribe button. Thanks. Do all the YouTubey things.
You have in this affidavit information that was gotten from the first search warrant that we talked, the cell site, cell phone, correct?
Aaron Hack just gifted 5 Legal Vices memberships.
Mapping.
Thank you so much, Aaron Hack.
Detail records.
If you're one of the lucky people that got the Legal Vices memberships, give Aaron Hack a super special
And
thanks.
then you also use Snapchat this.
And you new member peeps, go and start using those emojis. And most likely this weekend, we will have a special members only stream.
It's page 7, 12.
No cross.
Thank you, Gigi.
Thank you.
The little super sticker.
Sure. We'll be in recess. Dennis? You rushing break? You're good? All right, we're in recess. Can I see the camera guy for a second?
Uh-oh.
Yes, sir.
Uh-oh. Judge wants to see camera guy. That's not a good thing for camera guy. I'm assuming, wow, there you go, Marv White. Member for 11 months. Thank you. All right, so I'm assuming it's a 15-minute break. They didn't say how long of a break it was. Oh, that's not the one I wanted, was it? That's definitely not the one I wanted. Let's do this one. Oh, that's definitely not the one we want. Abort, abort, abort. Let's get rid of, okay, first things first, let's get rid of the cuck cage, shall we? Oh dear. All right, now, now let's go to this. We'll just kind of chill here for a bit, unless we want to, we need to find like the right one so that we can do things yet still see what's going on in court. But probably hear Strawberry snoring on the floor there. All right, let's get back to doing what we were doing, but with a little, damn it, that's not what we want at all. I don't know what view. How about we just do this? Let's get rid of the court. I can keep it over here on my feed and watch it as we go. That's the best way, because more of me is better than more of law and crime. That's what I say. And the camera just went dark anyway, so there we go. Hey, folks. We're on this break, and for those of you that are just joining in, for the next 15 minutes, we'll chill here. We'll go back to doing what we were doing at the beginning before court started. What they're doing here is, as I've mentioned a few times, they're going through the affidavits for the search warrants. And so because, to get these search warrants, somebody has to sign a document under oath that, this is what we want, this is what we're searching for, and here's the reasons why we think it's there and what the purpose of it is, etc. And so now the prosecution or the defense, depending on who's arguing their motions, right now it's the defense, they're arguing that some of the evidence that was collected should be suppressed or should not be allowed to be used at the upcoming trial. And so to argue that, they have to bring in the person that swore the affidavit, that gave the explanatory affidavit under oath, that served as the basis for the judge reading it going, oh, okay, there's a valid reason to issue this search warrant. And so that's what they're doing now. Moretti happened to be responsible for a great deal, a large number of the affidavits that served as the basis for the search warrants that they used to collect the evidence in this case. So they're bringing him in to question about the how, what, when, where, why of these search warrants. So they can find a reason, whether it's phishing, it's irrelevant, they overstepped some bounds, it was unlawful in some way. So they're trying to pick apart all of these affidavits and evidence collection techniques, reasons, and whatnot in an effort to try to have that evidence excluded from the trial. So it's just a bunch of motion hearings today with typical crappy court. I wonder what they're telling the court camera guy. He hasn't been moving the camera around too much, too inappropriately, I think. But I don't know. It's probably, I don't know. I have no idea what he's going to be told. There's no jury there to worry about. We'll just have to see if we have any clue, if we can see any change in the camera's behavior, or if the judge explains why he talked to camera guy. But I think what we did here, what you will note, is that apparently the microphone for the entire courtroom is right in front of camera guy, because you can't hear anybody. But when the camera guy said, yeah, okay, Your Honor, it was really, really loud, which means camera dude probably is just recording the entire proceedings with the internal microphone that's on whatever camera is being used, rather than having a good audio system set up in court. I don't know what this hot mic thing was about, because it's non-existent. It doesn't exist anymore on Law and Crime. Just as I finished my stream yesterday, I was going to go watch this. I started to watch it, and about 2 minutes after I got into it, they ripped the stream, they privatized it, and they started over again. I don't know. But I don't... Branches, can you raise volume levels on your end for viewers? Maybe your mic... well, I have it down to 10% because the court audio is loud. What I've done is I have the court audio up to 600% because it's such shit audio. And I have to bring mine down to 10% because everybody boosts their microphone to hear the court. And as soon as I talk, then people's eardrums start bleeding. But the court is out of session right now. They're on break. So I will bring my microphone back up to its normal level. And somebody, for the love of God, please remind me to put it back down to 10% when court comes back. All right, there we go. All right, this is back the microphone back at 100% where it should be. Well, I mean, it's just yeah. It's just there's just nothing I can do about the court balance because the court audio is shit. Mine is great, and then StreamYard thinks that everybody's too dumb to manage their own volume, so they actually reprocess it. And I know we talk about this a lot because everybody's like, why does your audio suck? It sucks because I know what I need to set it at, but StreamYard, and YouTube, they all do their own processing of the sound. So what I hear is not what the other guests on the panel hear. And what I hear, they hear, is not what you guys hear on the receiving end. So, yeah, there we go. Yeah. Oh, okay. The court camera's back on, but nobody's back in court. Never mind, they're back. So I'm gonna put court back up, and then I'm gonna pull my microphone back down. So everybody, boost your volume now. All right, I'm back down to 10%.
Yes, I did.
That was a very short break. I guess it was literally just a piss break.
It's a search warrant for the cell site data of the numbers involved in this case, one of which is the 9807 number, and the other one is Morgan Henry's number, and then another one I think is I have to actually say
One of them
is the 9807.
and that's Mr. Dennis.
Yes, the
Okay. And you're asking for what in this warrant?
yes.
What are you asking?
Why? Because
You had previously done a,
yes, sir. We wanted to see if they were out there at the crime scene prior to, so we took a larger window. However, T-Mobile will only, when it comes to timing advance information, will only give you 7 days. So they gave us a month of cell site data, but they didn't give us a full 30 days of timing advance, which is an additional report, which we're able to extrapolate a more accurate location, which we did not, we didn't get all the information that we requested.
okay, I'm sorry, but I was confused by your answer, maybe nobody else was. Are you saying that the data that you got from this search was really not useful for you?
It wasn't, we did not get all the data that we requested based upon how T-Mobile conducts business. Now, when it comes to, they gave us the cell site data, which every time the cell phone get off the tower, they gave us the tower, the sector. Okay. But we also asked, in addition to that, we asked for the timing advance. That's the third report that comes in with these. Now, timing advance, T-Mobile only restricts us to 7 days. But we were looking at a whole 30 days.
Well, the time you wrote this affidavit, did you know that T-Mobile only restricted it to 7 days?
No, actually, I did not. I thought whatever we requested, they gave to us.
So you were not as familiar with T-Mobile's practice as you thought?
Yeah, I guess that's accurate.
So what did they send you of the 7 days?
They gave us they gave us all the cell site data. Every time a cell phone hit on a tower in the sector, they gave us all that. But I was looking more for the timing advance, which we didn't get. We got a small portion of it. Exact how much, I can't say for certain, I don't remember. But when I analyzed the data, because I was trying to determine if they were out at the crime scene prior to the actual incident, is what this one was more focused on.
Were you able to determine whether they were or they were not?
They were not.
So Michael, my microphone is down to 10%.
This warrant.
To try to make up from the court being a 600%.
Predicated upon, but there is information in the affidavit that you got from the first T-Mobile search.
Yes.
That was mapping and T-Mobile cell records.
Correct.
And again, I just have to ask you, why 10-1 as opposed to 9-1, 18? I mean, what's the magic of that date?
I just started, I figured the homicide was 10/26, so I figured let's just go back to the beginning of October, that'll be a reasonable number, and we went from 10/1 to 10/27.
I have no further questions.
Any cross?
Disagree.
Oh, God damn it. That was the cameraman coughing, apparently.
In your experience, the phone companies change their policies and data retention periods on a regular basis, correct?
Ronnie James Dio is not impressed. Katie Lang questioning on
The
cross.
purpose of this warrant was simply, I mean, it was again a historical style site, but the purpose of this warrant, which is contained in the last line of your affidavit, was just to determine whether either the suspects had scouted out the crime scene prior to the homicides.
Correct, sir.
I have no regret.
Thank you. I have a question. I didn't quite, excuse me, I didn't quite understand your answer when counsel was asking you about the data that you received the data, and I was unsure of what you meant when were you saying that the data that you received reflected showed that the defendants or the phones weren't at the location prior to the incident?
Correct, sir. The purpose of this warrant was to determine if they were not at the crime scene prior to the incident. And the end result of just this warrant was we could not show them out at the crime scene prior to the warrant, prior to the incident.
But you got the data.
But we did get the data.
That's what I was unclear on. Did you say you didn't get the data? Or
We didn't get all the data we wanted, but the data I did get showed that they were not, the data was provided was not, they were not at the crime scene.
Thank you. Anything else?
Not on this.
Anything else?
No.
Thank you. What's the next one?
You
10.
know, 10.
And Travis, 9 is in evidence. All the exhibits 1 through 9 are now in evidence for the court exhibits, right?
Okay, so they haven't the judge is not excluding any of the evidence so far. Aaron Heck gifted the 5 memberships. We talked about that, and we talked about Gigi and the 5. This is all of the member chats there.
Marked as Courts Exhibit 10.
Brian Miller, best coverage of the YNW Melly trial officially because it was voted on and I won.
What is it? It is the cell phone for the seizure of actually this is for, okay, yeah, this is the seizure of the defendant's phone in the courthouse.
Okay, so this is for the seizure of Melly's cell phone. This is an important one.
The phone that you let this
Real quickly here, Marv White, thank you so much for the $5 super chat.
It's the Apple iPhone.
That was all the member emojis. Is that how you see it in your chat? Yep.
Number was 772-713-9887.
Thank you.
and the numbers, the text, the EI.
The IMEI, the International Mobile Equipment Identifier. Yes, the original warrant had the wrong IMEI.
We'll get there. What did the affidavit?
It is Try Gremlin. It's at 600%, and mine is at 10%.
The iPhone X, iPhone 10, with the MZ number, IMEI number, and cell phone number.
Okay, and what was that number, the IMI or whatever you call it?
International Mobile Equipment Identifier. It would ended in 14, I think it's 14 digits, 80s, ending in 8610.
Okay, and the phone that you seized, what was its international, what do you call it?
Mobile Equipment Identifier.
What was that?
It had another IMEI. That's why I had to do a second one.
The one you seized had a different what's the abbreviation?
IMEI.
IMEI. It had a different IMEI, correct?
Correct.
Okay, so it was not the phone that was in the affidavit of the warrant, correct?
Technically, it was, sir. It was just, we had the wrong IMEI. It was the right cell phone number, right MC number. It was the right phone we intended. It was just, when, because the original phone that was used in this case was disappeared, destroyed, no longer available. So they got a new phone, which got a new IMEI, and did not catch that originally in the cell records.
So that's not in the affidavit.
When I rewrote the second one to this, but you have to understand that this was a scribbler's error. This was a mistake made by me. But
The first one was stolen. Well, I mean, was destroyed.
It was a mistake, and I immediately wrote another warrant with the correct data. And also, there's a paragraph in that warrant, I'm sure it's gonna be number 11, is what it explains the error that I made, that the error that I corrected.
Okay, so let's appreciate what you did, but let's just go through this. You seized a phone with the wrong IMEI number, correct? Or the phone you seized did not have that IMEI number that is both contained in the affidavit and in the warrant.
Correct.
Okay. So therefore, you felt that it was necessary to do another warrant.
What I want, because I didn't know, when we seized the phone, I was assuming that I was seizing the correct, I was seizing the correct phone, it was just a different IMEI number. I was under the impression that what we were doing was proper. And
I was under the impression what I was doing was
until
proper.
afterwards, when we downloaded the phone, is then when I caught the mistake. Wasn't until afterwards.
So you already had downloaded a phone that the warrant was not for, correct?
Correct.
Okay.
I think he's got a good argument on this one.
You immediately returned the phone, correct?
No, no,
Oh,
You were in possession of a phone
I was in possession of the phone.
that
you did not have a warrant for it.
acknowledged did not comport with the warrant that allowed you to seize it, correct?
Oh,
Okay, so you gave it back.
Yes.
no! That was really loud. I'm sorry.
I understand what I did. I understand the error that I made. And so I corrected it. I resubmitted a new warrant to the state attorney, explaining that, what had transpired, full transparency. And then the warrant was then approved, was then sent to a judge. The judge then signed off on it. And
Well, let me ask you this. You said that you discovered this mistake when you had already, I guess, downloaded it. I mean, my terminology for
no,
electronic.
you're right.
Okay,
Right now.
when it had already been downloaded, correct? So you had already gotten all the information from this phone, correct?
Correct.
And you had looked through it.
No, I had not, it was just downloaded, and that's when I was, reviewing everything. Just
This is actually a very good argument for the defense.
Page of the cell-right extraction, and that's when I immediately noticed that there wasn't an error.
Okay, but you had the ability prior to this search warrant, the one that we're dealing with, not the next one, to do your job correctly and find out that in fact it was a different IME number, correct?
I'm not denying that, sir. I made a mistake, absolutely.
Okay.
You
And
made a
that's- so you did
mistake.
not- You're swearing that everything in that affidavit was true,
Exactly.
yet you did not do the research to make sure this was true, correct?
Exactly.
No, I did my I felt that I did my due diligence. I felt that I was acting in good faith, but I made a mistake.
Now, what other search warrants were used or the fruits of those search warrants?
So again, real quickly, when you give a search warrant, you have to specify exactly what you are going to search for and seize. And so he has to say, we are looking for the data contained on the phone with this IMEI number. And that is the only phone you are allowed to take under that search warrant, is the one that has that identification number. And he took one that did not have that identification number because it was a new phone.
T-Mobile search warrant that wrote on 10/29.
So essentially what the defense is arguing is he seized a phone that was not the subject of the search warrant, which the defense is going to argue that's an illegal seizure. And not only did he do that, he downloaded all of the data. And then when he found out it was the wrong phone, he didn't return it. So he held on to something that he knew he was not authorized to hold on to under with the search warrant that he had taken, he'd sworn the affidavit to. And they already downloaded data and were analyzing data from the wrong phone. I think the defense has a good argument on this one. And he's just arguing simple mistake. Oh, we seized the wrong phone accidentally, but after the fact, we went back and got a new search warrant for the phone that we had already seized, downloaded, and analyzed.
It does reference a second search warrant on the Jeep Compass.
Ring, 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 banana phone. I thought I was the only person in the world that knew that song. Yeah, see, he's just saying it was an innocent mistake, and they rectified it subsequently.
Snapchat account, I think it's on page 10 of 12.
But what he should have done was went, holy shit, we've got the wrong fucking phone, and gave it back, and then got the search warrant, and then went and got the phone again.
Just those two, sir. It appears here.
I like the defense's argument. I mean, the judge probably isn't going to exclude all of the evidence found on Melly's phone. I would assume the reasoning would be, well, they did get another search warrant for that phone, but I like the defense's argument. I got to say that. Because they can say, well, after they saw that there was something on there that may have been incriminating, they went, oh, now let's go get a search warrant for this.
Now, the purpose of seizing this phone was also to see whether there was any blood or saliva on it, correct?
I ended up doing a search warrant on I ended up doing afterwards, I think on the phone itself, we did a DNA test for blood, and it came back negative.
And that was because
the way it looks.
You were believed that it was the original phone or the phone that Mr. Dennis would have had on 10/26/2018, correct?
Correct.
So the phone you were seeking was the phone that had the IEI numbers that you put in the affidavit, correct?
Correct.
But the phone you got was a new phone with a different IEI number or whatever.
Yes, sir. I guess.
So the phone you seized was actually not the phone you were looking for because it did not have the right numbers on it, the right EI number, whatever it was.
My
And
sweet cherry pie. What a
new
good
phone
song that is,
did
Eric.
not have the saliva or the blood that you were looking for on it, correct?
Correct.
It won't be a mistrial. They would just exclude all of the evidence from that phone
Now,
if the judge was
who
so inclined.
analyzed this encrypted information in this one?
This phone was downloaded by Detective Zeller, and I'm the one that read the cell phone.
Did somebody try to recover the
Nice.
items on it?
When that is in the actual Celebrate report, what's deleted, what's not.
Okay, and that's under this warrant?
Let's see here.
Really?
Yeah, it's in there. It talks about it on page 4 in the affidavit. I'll go into the actual warrant itself.
Holy shit. It's that easy. Holy shit, Brad. Oh, fuck me. I was 54 years old today when I learned this. *#06*. Yeah, that brings up the IMEI and the serial number. Holy shit. Moretti, it ain't that fucking hard. It ain't that fucking hard, brah. Huh. God damn. Shit.
It actually on page 3 of 6, it starts talking about the ability to undelete files, and page 4 of the affidavit goes into more in depth about recovering deleted files.
So based upon this warrant, you look to uncover deleted files and things of that nature?
Yes, sir.
Okay. And what was revealed?
I don't think there was much deleted data recovered.
Okay. What data was recovered?
What was ever turned over to the state, which then turned over to the full extraction of the cell phone.
Okay. And therefore, that would tell us all the people that phone called, correct? Or received calls from.
Well, yes and no, because if certain platforms, it's not going to show up. Like just say, if you and I are talking via WhatsApp.
Not a detective whose job it is to be aware of shit like this. Not be aware.
It's not going to show up on the call.
That's funny.
It's going to show up as data, so it might not even.
Well, we'll get there.
Okay.
I don't know things like you know. So I started off with calls. We would show all the calls. And then my vernacular calls are when people actually talk to each other.
Yes, it will show a call log.
Okay. So therefore, there's a log of people that called him that have no bearing whatsoever on this case, correct?
Correct.
How were they segregated out?
They weren't, sir.
What other data did you get?
Pictures, text messages.
So let's do pictures. There are therefore pictures that have nothing to do with this case. How were they segregated out?
Only the pictures or videos in which we used in this case were identified to the state.
Okay, so there's no separate log or whatever of what was segregated that is innocuous or innocent or irrelevant. What there is you just picking out what you think is relevant to the prosecution.
Correct.
And the rest remains, and then the state gets the rest, we got the rest, and we got everything, correct?
Correct.
But we did not get what you segregated out. It's again on the tail end of your last report.
Yes, sir.
Okay. So, but it's not delineated in any information we got through discovery other than that.
Correct, sir.
Wow.
This was downloaded by somebody else, not yourself.
Correct.
Who made the determination of what fit into the warrant and what, the terms of the warrant?
I wrote the warrant.
I know you wrote the warrant. Who determined what was what of the material that was downloaded was in fact relevant to the warrant?
This is a completely different search warrant. This is the search warrant for YNW Melly's phone, not his mother's phone.
And we put into a format.
Different warrant.
It's readable, and then I'm the one who reads through that.
So you read through the phone?
Yes, sir.
Okay. And then, so it's you who are determining what is relevant, what is not relevant, what you want to use, what you don't want to use? Just you?
Yes, sir.
Deleted that?
Yes, sir.
What's that?
Huh.
Councilman Cross?
Yes.
Okay, let's see what Katie Lang is going to do to rehabilitate that.
Just want to clarify, so this warrant, you sought the phone number, the INSI, which is the IMSI, and the INEI, spelled I-N-E-I, clear. That is based upon the original information you got from the call detail records for T-Mobile.
Yes, sir.
You weren't aware that 3 days after the crime, the defendant replaced his phone and got a new phone.
I was not aware of that at the time.
There was a discussion with, about Detective Zeller making a download of the phone and to really just kind of shorten, he hooks the suspect device or the device to be searched up to a device, typically Celebrite, and will download a copy of it for then you to actually conduct the search warrant examination.
Correct.
So Detective Zeller does not actually search through the device itself.
Yes, sir.
Well, how do we know?
When you began your search, I believe it was asked, you almost immediately realized that the IMEI did not match.
Correct.
So you did not actually get to conduct your search based upon this search warrant.
How do we know?
And it was when you realized that the IMEI had changed, is that when you determined the defendant had in fact purchased or obtained a new cell phone?
Yes, sir.
And that's what the next warrant, that was what your subsequent warrant was for, was realizing that the IMEI was different, you obtained a corrected warrant to reflect the device that was actually in your possession.
Correct.
After you downloaded the data from the wrong phone.
The device that the defendant had replaced his phone with, it was the same make and model, it was an iPhone 10.
Correct.
You were asked about going through the records and like for phone calls such as through WhatsApp. If calls are made through WhatsApp, those are not reflected in the call log, are they?
No.
Katie Lang does kind of have a nice tenor or a slightly baritone voice. You must have an iPhone. Apparently it's an Android thing. Brad can tell you what to do. Brad knows. I have no idea what the hell I'm talking about. I just found out about it 5 minutes ago. While we're waiting here, Xenothium 15, Your Honor,
In the warrant,
88 Binger said I did nothing
itself, you
wrong.
also specify with
Thank you so
particularity,
much for that.
3 items of primary, there were multiple items, including identifying the user of the device. But there were 3 items in particular you were looking for. Files or data contained on the seized items and electronic storage media that show ownership or control of the items contained regarding the homicide. This is on page 3 of 6 of your warrant. So you were looking for that information. Any files or data contained on the electronic storage media relevant showing which individual had control of the seized item at the time of the violation of the crime, where data was accessed, created, or modified. And any listings of web addresses, email addresses, screen names, telephone contacts, communications, images, or other personal identifying information in printed or electronic form to be used to identify co-conspirators. I mean, there are other items, but those were 3 of the items that you were looking for, correct?
Correct.
And looking for evidence of other evildoers on the phone logs. And a super special shout out and thanks to all 500 of you watching live right now. Bless y'all. Thanks for being here. Thanks for supporting the channel. Love to have you here. Please subscribe if you haven't done so. I deeply appreciate that. We're covering the Melly trial from gavel to gavel and all points in between.
That's all I have for this. Wow.
Councilors, any redirect examination?
Briefly.
You mentioned WhatsApp, and the state just mentioned WhatsApp. Does Mr. Demmings have a WhatsApp account?
I'm not sure, sir.
Then why was this being discussed by you?
It was just my way of explaining to you that not everything shows up on a call log.
Okay, so you did a thorough investigation of Mr. Demmings, correct?
Correct.
Okay. Did you check to see if he had a WhatsApp account?
I don't remember seeing a WhatsApp account for him.
Okay.
Oh no.
Yes.
Next.
Moretti, you're not doing so well today on this particular motion. So if it's not there, why the hell are you talking about it?
What is so special about it?
I was just explaining to you that not everything shows up in a call log. So there's many different types of talking platforms, communication platforms, that's not going to show up in a call log.
Yeah, but if he doesn't have it, why are you talking about it? Answer the fucking question.
But if there's text now, text free, there's a bunch of
Did he have any of those free texting apps on his phone?
VoIP or internet type platforms.
Why are you talking about shit he doesn't have? That's the question.
When you checked on the IMEI number and you saw that it wasn't the correct one that was in the affidavit or the warrant, how long did it take you to contact, I guess this would have been Apple or whatever, and find out that in fact this was not the same phone?
I was able to determine, just going back to cell phone records, that this was I made the error and put the wrong IMEI down.
How long did it take?
That day, I realized
Whoa.
that day.
Did you make an error and put the wrong
IMEI?
Did you put the wrong number down, or did you put what you thought was the right one down, and then you found out it wasn't? That's a big difference.
You did this warrant, so this warrant would not have had the wrong number, correct?
Sir, I'm not denying the fact that I made a mistake. It happens. I'm human.
So you're going to convict the guy on a mistake?
We ready to go on to the next one?
I don't know if the state has any further.
Typically, it's cross and redirect and that was done, right?
Well,
Do you have any further questions?
No, Judge, I'll have some clarification and argument later, but nothing further this brings on this.
Wow.
We're going on to number 11.
I think that's the best argument that the state has had, the defense has had so far, as far as getting evidence excluded. I mean, don't hold your breath that the judge is going to actually exclude it, but
We'll let you look at this lifeline.
Danielle says legal vices. You have 3 Danielles now. Yeah, we've got lowercase. We've got like little d, who's actually the big D who's actually the little d, and we've got no mod D. We used to have double D. Now we got triple D. So hey, I'm all for that.
Do you recognize this?
Yes, sir.
What is it?
This is the updated search warrant for the cell phone.
Yes. Again, the court is at 600%, and I had to pull my volume down to 10% so that I didn't kill everybody's ears. Yeah, everything is really super low. Turn up the volume.
And first of all, as far as information in this warrant, you have this from information you got from the warrant we've been calling number 1, the cell site, the cell phone, correct?
Yes, sir.
And Snapchat.
Yes, sir.
Now you're part of the triple D.
Again, there was encrypted information. Who looked into that?
I'm the one that did the actual reading of the phone.
Okay, and how was it encrypted and what was encrypted?
Oh, you're talking about what's in the affidavit that talks about encrypted data, is that what you're referring to? Which section, sir?
What page on that? Asks you to look at encrypted data, or it gives you the right to.
It gives me the right to look at it.
Yeah, I don't know if you did it.
We didn't come across any encrypted data.
Okay, that makes it easy.
Okay.
And you are the sole determinant person as to what fit into the item that you're allowed to seize.
Like
Right?
that.
And what I mean by that is you got basically all the records, and then you went through them and you determined what fit under that warrant and what didn't.
Correct.
And what fit under that warrant, as far as you're concerned, is what was relevant to the prosecution.
Correct.
You did not segregate any innocent or innocuous material so that they are put aside so that the rest of the world could not see it, correct?
Correct.
So you sent them everything over in bulk to the state attorney's office with, and the only thing you did was the notation on the police report. This is the information you got from this one.
Correct. It's the way I do it in all the cases, sir, because I don't want it to, exclude what, may be deemed later as exculpatory evidence.
Now, how far back did the information on the Apple iPhone here go back, meaning the dates of the information?
It went back as long as whatever it was stored in the cloud.
Okay, so that would not just be the date this phone was purchased, but it would go all the way back to when, since you know that it's not.
No, it doesn't. Little bit of confusing it. When you get your iPhone and you input your iCloud ID, all that data that's in that iCloud is then imported into the phone that you have. Now, if there was other data on that phone from a previous iCloud account, that's not going to be in there. The way that the iPhone is set up is that it's that iCloud. That phone is just the conduit to the cloud, to the data. And so the phone can change many times, but this data is going to be the same.
Okay, so again, so this would be all the data that any phone that Mr. Demons had,
If he had the same iCloud, yes.
it would come into this phone.
If he used the same iCloud on other phones, then yes.
Which is the other IMEI number, correct? Okay, so that would all come back into this phone.
If he used the same iCloud on both accounts, on both phones.
Did he?
To my understanding, yes.
Okay, so that all came back.
Yes, sir.
And you don't know how far back you were asking for information?
None, I did not.
We certainly know it was prior to October 1st of 2018, correct?
This warrant here is for the downloading of a phone. It doesn't specify a time frame.
So it's all the information the phone has.
And all the information in the phone.
Okay. No matter how far back it goes.
Correct, sir.
No matter how irrelevant to this thing is.
Correct, sir.
No matter how many pictures are innocuous that have no bearing on this.
Correct, sir.
Okay. No matter how many innocent people's names are in the phone that have no relevance.
Correct, sir.
They're included too.
Yes, sir.
And they were not segregated by you, as you said, they were just kept in the large folder of all the records, and only segregated with what you intended to use it for.
Correct.
Nothing else.
Councilors, any cross of this witness?
I just kind of want to clarify, because I think it got muddled along the way there. When you set up you purchase an iPhone, you set up, in its essence, an iCloud account to go along with that device.
Correct.
And if that device syncs to your cloud account, and any data that you put on your phone, as long as your phone is set up correctly or properly, that data gets backed up to the cloud.
Correct.
So phone numbers, pictures, messages that might have been saved, location services, and I believe it's by default, that gets backed up to your cloud.
Correct.
And then if you were to purchase a new phone, you decide to upgrade, you lose or discard your phone gets broken beyond repair, and you purchase a new phone, when you put in that Apple account ID, the one that you set up originally, all that backed up data downloads to the new phone.
Yes, sir.
So when Mr. Demons purchased a new phone, any synced data that he had from that phone at the time of the crime would have been essentially downloaded or ported over to this new phone that he acquired.
Correct.
He doesn't know how to work the microphone. He's just yelling.
Now, you asked for a lot of items in your warrant, and as counsel was pointing out, that you go back and you're looking for things that could go back from well before. But one of the purposes of the warrant in there, and you do spell it out, is you have to identify who the user of the device is, or in this case, who the user of the account is, correct?
Correct.
And one of the ways we do that, you brought up earlier with one of the other motions, is by establishing a pattern of life.
Correct, sir.
And what are things that you would look for in terms of a pattern of life, just to establish that a designated person is in fact the primary user or owner of a device?
You can tell by the way, the manner they message, who they message, the frequency of the messaging, pictures, videos, selfies, all that is indicative of one user. If you look into the accounts related to the phone, you've seen other accounts, anything that goes back to a specific person.
That could even include things like bank accounts they might log into, Instagram accounts they may log into.
Yes.
Those all of those factors going back both back in time and forward in time help to establish who is in control of an account at or near the time of particular interest.
Correct.
And the longer a person is in control of a device before or after, that would suggest that person is in fact, most likely in all probabilities, the sole user of that device or account.
Correct.
Thanks, one moment. Yes.
Oh yes, your phone is not the cloud.
Redirect examination.
You should have a different warrant for the cloud, because one is for the physical phone itself, and the other one would be with Apple. You'd have to serve it on Apple to get the information
All
out of the
those nice
cloud.
things that Mr. Griffiths just said, are in your affidavit?
Yes.
Why not?
God damn it, cameraman! Knock that fucking cough
You
off.
didn't go into the pattern of life. Did you?
Yes, I mean, technically by the way when I read the phone, I could easily determine whose phone that was, and there was no one else.
I'm talking about the affidavit.
No, sir, that's just something that we do in law enforcement. Not everything I do in law enforcement is going to be, in the affidavit. These affidavits are long enough as it is. I can't put every single aspect of the investigation, what we did, what we think, into these warrants.
You can put some of it though.
You can't tell who actually was using the phone at a time, at a single time, can you?
If your question is, can I tell who's using a phone at a specific time?
Right.
Yeah, actually, I think, yes, you can. If you look at, who they're talking to, the contents of the conversation, what's being said, what's being done, yeah, you can definitely tell, like in this case here.
Or somebody who has knowledge of the conversation.
No,
Well, there's also body cam footage. We'll get to it one of these days.
Right after the homicide, Mr. Demons was dropped off west of the hospital on Pembroke Road on 178. He is then talking with Frederick Givens, Frederick Banks, and you can see a conversation between him that's within context of themselves. And you can see who is sending and who is receiving. Sometimes you have to apply common sense, but we could definitely tell who was using that phone that night. If you look into some of the other messaging that day, right after the homicide, you can see other people was calling him, hey, Melly, are you okay? I think there was one messaging from his grandmother, Jamel, your grandmother, are you okay? Stuff like that, so you have to look at the totality of the circumstances, look at everything to make that determination.
Let me ask you this, as far as we're talking about fruits and we talked about Snapchat and we talked about the T-Mobile, this warrant also is based upon the fruits of the previous warrant where you seized the phone, correct?
Correct.
And I say the previous warrant, I think this one is.
This is 11.
That would be 10.
Yes, sir.
I have no further questions.
We're going on to question motion number 12.
Yes, we are.
Suppression motion number 12 coming
We
up.
have 11 marked in evidence, correct? George?
And in the meantime, member for 8 months, Little Dog Chaz. What are we puffing on today? Thank you for your amazing coverage, Legal Vices. Well, you're welcome.
It'll let you look at 12 while I
I'm
get my.
a little embarrassed by what I'm smoking in my pipe today because I'm trying to get rid of what's in this bottle so I can put other stuff in it. I am, in fact, smoking pumpkin spice tobacco. Do you still like
This
me,
is for
chat?
the Gmail
Do you
accounts.
still like me?
YNW Melly 100K Management and YNW Melly Booking at gmail.com.
Did you get any evidence from this?
No, I believe I had to expand out the second warrant after this. I had to expand it. We saw there's communications of gang affiliation, but I believe that the next one to follow up one to this is where we get the actual gang Bible being exchanged, which then it was used in previous trial.
Yeah, I didn't know they made pumpkin spice either. So when I saw it 3 years ago, I bought it.
I don't want to waste time on this. There's no need.
And I just need the bottle now, and I don't want to waste the tobacco. So I've been forcing myself to smoke this shit for
I
a
don't
couple
have
of
the data in
months.
front of me. I believe, to the best of my recollection at this time, I don't think we got a lot.
I
out of this
apologize.
Specific warrant. I had to expand it out.
Got
by
one more
a
pipe's
month or
worth, and then you'll
something.
never hear it again.
That is when we got a lot of the gang information.
Who sorted through all this evidence?
I did, sir.
Same way, as you've gone through?
No difference, sir.
Well,
I'm not
No
that
different than the other one.
basic.
so just to paraphrase, what you did was you went through all the data that you could get from these accounts.
Yes, sir.
By the way, what's the time period of these accounts?
If you look in there, it says property provided by Google. It says all records should span from October 1st, 2018 to November 1st, 2018.
Okay. And you chose October 1st because that seems to be the date you like to choose.
Yes, sir.
Okay. There was nothing magical about October 1st. And so you have that date, you have that in there, and you get all this information from Google, correct?
Correct.
And how does it come to you in what form?
It's the same thing that it comes in a encrypted file, which we have to decrypt and.
It's not bad if you like pumpkin spice.
Again, you were the sole person to review.
I don't. I was just
So that
curious.
means that you went
I was
through
spice
everything
curious.
on that account, and then you determined what is relevant to your investigation and what is not.
Correct.
And again, you don't put to the side any innocent or innocuous document. You put aside, or you keep all the documents that, I'm gonna rephrase that. What you do is you take the innocuous and the innocent documents and you keep them with other documents that for you, there is no relevance in the prosecution, correct?
Correct.
Okay. And so they are commingled with documents that may not be innocent or innocuous. They're just not relevant as far as you're concerned.
Correct.
Okay. And the only thing that's segregated, and it's not physically segregated, it's segregated by you putting it in your police report, that these are the things that I think are important to the investigation.
Correct.
And this one is based upon the fruits of the cell site, number one, source, correct?
It does reference that one. The reference to Snapchat.
Anything else?
No, sir.
One second. Nothing else?
No cross. No cross. Thank you. So we're on to,
All right, that was just kind of a run-of-the-mill thing. That was a
number 13, is that right?
little Hail Mary nobody really cared about. See, they've got to do all these motions. Otherwise, it could be argued that they didn't do a good job. They know the vast majority, if not all of them, are going to be rejected, but they've got to try.
Sorry. Sure. We arrange that, we'll be in recess for a minute.
All right, folks, it's time to turn your volume down again because I will be turning up my microphone volume to normal levels right now. Okay, we're at 100% again. We'll remain there until the court comes back. Let me mute this so we don't do that. All right. Their last break was just a quick short break, so I would assume it's going to be about the same. So let's bail out of this. Now, again, we at the beginning. Well, I guess first of all, I want to talk about that one motion. I think that was a great motion by the defense. It seems to be one of their strongest so far. That they seized the wrong phone, and what should have happened was they should have said, "Give us that phone right there in your possession." They should have got it. They should have run the ID check and went, "Oh, wait a minute. This isn't the one that's listed on the search warrant," and given it back immediately. It should have been given back immediately to the owner of the phone, which is the defendant. They didn't. They held on to it. They downloaded it. And then they went and I guess they'd analyzed enough of it to see that it wasn't the phone they were looking for, and then they went, "Oh, no harm, no foul. We'll just keep this." But now we'll go out and get a search warrant for the phone that we have in our possession. That's not good. I don't like that at all. Because he said, "Oh, I wrote the wrong number in the affidavit." No, he wrote the right number. He wrote the right number that he thought that he should have been getting. He didn't know the phone had been changed. So it wasn't that he knew the phone had been changed, and he had a like some sort of brain fart and wrote down the old number instead of the new ID number he knew. That doesn't sound at all like what he did. He said, "Oh, we have it for this particular ID number." They got it. They just assumed it was the phone that they were looking for. That's why I like the comment. This is not the Android you're looking for. Yeah, so it wasn't. I don't think it was at all like he was saying. There's a huge difference between, oh, I knew there was a new number, I wrote down the old number, and I immediately rectified it, versus we took the phone that we thought it was, we took the phone, we downloaded the phone, we opened it up, and then we realized, holy shit, this isn't the phone that we were supposed to take. We better hurry and run out and grab a new search warrant for this phone. That's two very, very different things. So yeah, I don't like that. And you can hear Strawberry probably chewing on this bone on top of the aluminum, where she just knows it makes a lot of noise, but we'll deal with it. All right, now I want to go back and look at the things that we were looking at earlier at the beginning. This new discovery that the prosecution is turning over. This new evidence was delivered by the prosecution to the defense prior to yesterday's hearing. Let's see where we are. Need to stop that stream and bring up the PDF file. All right, let's backtrack a little bit here. The state put in a new affidavit, three new affidavits regarding now this is going back to the search warrant for YNW Melly's mother's phone, which is different than what we're dealing with now. So don't confuse what we're talking about now versus what's actually going on in court right now. This was in relation to yesterday's hearing, which no longer exists on Law and Crime. So the state they're submitting supplemental discovery. 3 subpoenas: Bank of America records, Cash App records, and Western Union records, and screenshots of text messages between Michelle Boutros and Detective Mark Moretti. You'll recall that she was saying that she wasn't aware of what was going on. He executed this warrant outside of his jurisdiction without a local officer present. Later went back and asked the local officer to testify that he was actually there when the warrant was served, when everybody knows he wasn't actually there. She said, "Oh my God, the lead detective is soliciting a witness to lie under oath to create this affidavit for this, so that this will be a valid search. I am never, ever going to work with this guy again." She rats him out to the boss. That's what the prosecution has said. That's what she said herself. So to counter that, the prosecution has introduced this new evidence. Screenshot number 1 is from 10/12/22. This is the day of the incident, the day that this allegedly illegal search warrant was done. God dang it, we're back in court already. I hate when that happens. All right. We'll have to do a new stream for that. We'll just have to start early tomorrow and go over this stuff, I guess. All right, volume going down. Boost your volume now. All right, I'm back down to 10%.
Yes, sir.
there?
Yes, sir.
When did you become the Broward Sheriff's Office deputy?
Still with the city of Miramar.
Okay, so when you were swearing that you were Broward Sheriff's Office deputy, that is not true.
Correct.
Oh my God, what? All right, folks, please remember to hit that like and subscribe button. I would deeply, deeply appreciate it. We've got exactly 500 people, 512 people here now, 400 likes. Let's get us up to 500 likes. And please, I'd love to have your subscriptions. We go through this, sign up for the notifications. Let's follow Melly together.
October 1st to the, I guess, November 1st or October 31st.
The last one. Correct.
Okay, and so you went back to September 1st.
We have 30% of the number that Law and Crime has. That's awesome. Thank you for being here and not over there. Well, speaking of Law and Crime, let's put up the cuck cage. There we go.
Correct.
Gotta ask you, why September 1st?
It just went back 1 month prior because we could see communications with known gang members, but we
Gang.
just went back one previous month, and then that's when we located the gang Bible and all the gang documentation.
Okay, so that, it had what you were looking for, so you didn't need to go back to August 1st.
Correct.
And this warrant is based upon the previous warrant, correct?
Yes, sir.
And it's also based upon what we have, when I say previous, it's our number 12. It's also based upon the affidavit and search warrant for the cell site and cell phone, which is number 1, correct?
Yes, sir.
It's based upon Snapchat also.
Yes, sir.
And again, all material that came into you was segregated in the
Yes.
attachments.
Gang Jesus.
Correct.
Yeah.
You took what you thought was relevant and you notated it so that they would know in your computer book what you believed was relevant. And then you had the whole blank, I don't want to say blank, comprehensive file of everything that came under the search warrant, correct? Correct. Okay. And there was no segregated, innocent or not innocent documents, pictures, or anything like that. Correct, sir? I have no other questions.
Any cross-examination?
Yeah, just briefly.
Yeah.
Typed in the last page of your affidavit, you swear as a Miramar police officer.
Yes.
All right, folks, we are about $60 away from Doggo Cam here, so
She's also a Miramar police officer.
Yes, sir.
yeah, we're
This warrant, just in short summary, is an expansion of the previous Google warrant. Because in short, Detective Polo had discovered some evidence of gang activity in other devices, and there had been some gang activity in the Google return. So you were seeking an expanded warrant to go and retrieve that gang information from what was returned in the Google account.
Yes, sir.
Thank you, Rick. Thank you.
We have no other questions for Detective Moretti.
Is he excused?
This motion is, from these motions,
Anything else today that you need to Detective Moretti?
no, there's nothing else on.
Thank you. Thank you, sir. You may step down, you're excused.
all right. Moretti's done for the day, it looks like.
We have all the affidavits, warrants, and evidence down to the 13th. All right, so first motion, I guess.
Your Honor,
I guess you're on Earth, says the subtitles.
Go through each and every motion before everybody out of their office. So what I'd like to do is rely on the motions I have filed and to go through a little bit of case law.
All right, they're going to make some arguments here. Cool.
Now I just have a bucket of case. I submitted to the court several cases. I would ask the court, there's a opinion there by Judge. There's an opinion there by Judge Hirsch from Dade County, Judge Milton Hirsch. I do not believe that I could ever write a motion, order, opinion, anything as eloquent as he spells it out. I would ask this court to look at that. In that opinion, he talks about these types of warrants that we've been dealing with today, these applications. And he says that he will never sign one of these again. And the reason he puts in there is because these are open-ended warrants. They are general warrants, and they violate the Fourth Amendment of the United States Constitution based upon the overbroad and general warrants. And he goes on to explain that it is common, as you've heard here, for police officers to use that language that we've gone over about the segregating, about to receive all the documents and everything like that. And he points out that we don't bend the Fourth Amendment to the internet or to electronic data or electronic media. We bend electronic media data to the Fourth Amendment. The Fourth Amendment is the Constitution of the United States. And he goes into basically explain, and again, I ask you to read the decision, it's eloquent, but he goes on to explain that this is exactly what the framers of the Constitution were arguing against. For the lead detective in this case to be able to go through every document and then decide what is relevant violates the Fourth Amendment. It is an open-ended warrant. It is, give me everything and I will decide. That is exactly what the framers of the Constitution were trying to get around, not get around, they were trying to outlaw.
Got to agree with that argument.
I'm giving you the case of Ingraham State. On page 3 of the opinion, and it is right above, if the court is going to look, if not, I'll just read it.
Go ahead, read.
Thank you. It says, we agree with this argument in this appeal that the trial court erred in denying the motion to suppress because the search warrant failed to describe the items to be seized with particularity.
You have to describe them with particularity.
Authorized a general search.
You're only authorized to take exactly what it says that you're allowed to take.
Violate fundamental rights. Also, later on in the opinion, in Abraham, it says, the particularity requirement makes general searches impossible, and it limits the executing officer's discretion when performing a search. Well, you heard from the witness stand on all these. He had total discretion. He determined. There was nothing by the warrant that limited his discretion. The only limitation was what he thought that he could use in the prosecution of this case. In Green versus State, which I gave you, for a search warrant to be valid, it must set forth with particularity the items to be seized. I've also provided to the court a case of Arizona versus Camden. And the only reason why I presented that, it is a car search case where they, and I don't even use a search warrant, but it talks about the fact that police should not have the right to rummage through the personal effects of a citizen. And that's exactly what each one of these warrants allowed Detective Moretti to do, to rummage through the email accounts, the Instagram accounts, the Facebook accounts, the whatever accounts that I don't even know all the types of accounts that they have, allowed them to rummage through those accounts just like it was a physical place, picking and choosing what they liked and discarding what they didn't like. And that is a general warrant. already Judge Hirsch's opinion. He cites a case called Dizella versus State, 390 Southern 2nd, 97 at 99. If a warrant fails to adequately specify the material to be seized, thereby leaving the scope of the seizure to the discretion of the executing officer, it is constitutionally overbroad. And that's what it was left up to, the discretion of the officer. It is constitutionally overbroad. He also cites a case, a United States Supreme Court, Low-High Sales, L-O-J-I Sales, State versus New York, 442 U.S. 319, 325. And here, this is in diametric opposition to the command of the Fourth Amendment.
Well, actually, I just came in. What's happening right now? The defense is arguing that evidence should be thrown out.
While a search is being conducted, an item seized or after the seizure has been carried out. And that's exactly. And determine the extent of the warrant as it was being carried out. Not prior to them getting the information, but after they got it all, they went through it and determined what was relevant as they were looking at it. Again, in opposition to what Low-High Sales says. I suspect that the state is going to argue at some time good faith. Good faith. Good faith is an exception to whether or not a warrant that does not show probable cause or a warrant that is executed improperly why the evidence should not be suppressed. In Ingraham at page 4. First, the good faith exception established in U.S. versus Leon was specifically held by the Supreme Court not to apply to where a warrant may be so facially deficient, i.e. in failing to particularize the place to be searched or the things to be seized, that the executing officers cannot reasonably presume it to be valid. In Green, however, the facial invalidity of the warrant precludes the application of the exception. This is so because the executing officers relying on a warrant which fails to particularly describe the items to be seized cannot reasonably presume the warrant to be valid. Also, I've given the court Burns versus which is a case not from this jurisdiction. It's from D.C. court. It has a federal United States versus Burns, but it's the D.C. local court. And I've only given it to the court, not because it's controlling law here. It's not, at best, it's persuasive. But I think if the court reads it, it will get a great understanding of the whole thing. At least it would help me out. Maybe the court can get some information from it. But in it, they say the affidavit submitted in support of the warrant was so lacking in the indicia of probable cause as to render official belief in its existence entirely unreasonable, and that's why the good faith exception did not apply. Again, Burns quotes Brown versus Illinois, which is a Supreme Court United States case. The warrant was so facially deficient, i.e. failing to particularize the place to be searched or the things to be seized, that the executing officer could not reasonably presume it to be valid. I've given the court the case of Redhead versus State, 347 Southern 3D 415. It's a 2022 case. Thus, the issue before the court was whether, given the totality of the circumstances, a well-trained officer with the same information would have believed the warrant to be valid. I've also given the court Coronado versus State.
Excuse me one second. You all right? Get a drink of water. You all right? Yeah. Sorry.
And Coronado versus State, reemphasizes the things I've already said about that.
Hey, Chandler. Good morning. Welcome.
You have to look at it whether a reasonably trained, objective police officer would know that it was a valid or invalid warrant or affidavit. And then I've also provided to the court the case of Slytherin versus State.
Slytherin versus State? I haven't heard that case before.
And in there it says that the affidavit itself must assert probable cause, and if it does not, then there cannot be good faith.
And that's saying the affidavit to get the search warrant has to show probable cause that there's a reason to get it and that you have a reason to believe it is where you say it
The case
is.
of Zarkadoulis versus Tony. Zarkadoulis versus Tony is a case of, I think it's about 8 months old, but maybe a little older than that. And you have it there, Your Honor. Zarkadoulis is from the 4th DC. And what happened in Zarkadoulis was it was a civil forfeiture case, but they filed a motion to suppress it. And during the motion to suppress, they learned that the affiant of the warrant was not the person that went to the judge with it and had signed. And it talks about the affiant may have had all these trainings and whatnot. But the person who submitted the warrant didn't have it, and the person who signed it didn't have it, because the person, I shouldn't say the affiant may have had it, the person who was supposed to be the affiant may have had all this training, but the person who actually signed the warrant and submitted it didn't have all this training. They went.
Something's going around.
Sorry.
They don't mean to interrupt you, it's just.
No, I'm wondering if I was typhoid, whatever, yesterday.
You okay?
Yes, I've had that for since the Concord years of working.
I'm sorry to break you.
It's okay, my train is always a logo.
It's a tactic by Katie Lang there to start coughing at the important
What they go on
parts.
to say in that case is that
Just kidding, Katie.
there were things in it, in the affidavit, that needed to be explained by the person's training. When it was going into money laundering and things like that. Well, the affidavit didn't explain why this detective would know what money laundering is, or would know what any of the crimes were in there. And that's what we have in these affidavits. Detective Moretti just says that sometimes he's a detective with Miramar Police Department and nothing more. Sometimes he says he's a detective with Miramar Police Department and he's in the homicide division. That's all we know about it. We don't know his training. He says based upon training and experience, but he doesn't say what that training is. He doesn't say what that experience is. As far as what his role is, when he doesn't say he's even a homicide officer, we don't know whether he's a school resource officer. We certainly don't know from the affidavit what his role in this investigation is. We don't know, that's why I asked him things about the cell sites and stuff like that. How does he have that information? It needs to be spelled out in the affidavit. I have done this training and I know about cell site information, and cell sites do this. I learned this in a 40-hour class. I took such and such a thing, or I worked under officer so-and-so.
Or confidential informant told me such and
Whatever
such.
it is, something to say, I have the requisite knowledge to say the statements that I have put in the affidavit are true and are correct. And his affidavits are void of that. And that alone, following Zarkadoulis, would make these affidavits, I don't know the word is valid, not able to support probable cause. And I would ask you to read Zarkadoulis, because I believe if you do, you'll come across with the same understanding that I did.
I like this argument a lot.
Lastly, or almost lastly, you have an inevitable job. Not that being a judge is always enviable anyhow. But you need to determine the credibility of Detective Moretti. cannot find that he tells the truth or that he is honest, then you can't determine that when he swears to these affidavits that he's swearing to the truth. What do we know about Detective Moretti? We know two things. Either he lies or Michelle Boutros lies. One of the two. Simple as that. They tell two different stories. We know that Michelle Boutros has a husband that's a police officer. We know that Michelle Boutros never had a problem with Detective Moretti. We know that Michelle Boutros has never filed a complaint or an allegation against any other police officer in her 20 years. We know that she had nothing to gain from this. In fact, she's had things to lose. She's gotten flack from administration. She's had fellow people of her office, I will say, brutally cross-examined her, trying to make her look like a liar, a person from her own office. She had nothing to gain from this except her honor and upholding the truth. Detective Moretti, on the other hand, got a reason to lie. Why? Because he tells the truth. He's admitting to soliciting perjury. He's admitting to trying to get another officer to falsify information. He's admitting to probably losing his license to be a law enforcement officer and possibly prosecution.
Holy crap.
He has a reason to lie.
Yeah, that's true. Those are the things he's facing.
Who is telling you the truth? And if you determine that Ms. Boutros is telling you the truth, then you know you're listening to a liar sitting on that witness stand, testifying the entire time in front of you. If you know that Michelle Boutros was telling the truth, you cannot rely on his affidavits because it's an affidavit of a person that you now know through this case cannot be trusted to tell the truth. There was one affidavit and one warrant in which he basically said that he was speculating that they could get information. I'm going to be candid. We've gone through so many of them. I don't recall which one it is. I know it's in my motion. I'll ask you to rely on it. But I've given you the case of Smitherman versus State. Speculation is not grounds for the issue of civil law. Thank you.
Wow. Let's see.
Just to start as a preamble, Judge, I know I had a continuing objection, but again, just want to remind the court that the testimony of witnesses is available for the court to consider in a motion to suppress based on the grounds that the defense has filed. Starting first with Judge Hirsch's
Thanks for backing me up, Flux.
order. I've seen that before, and unfortunately, I really disagree with a lot of the findings in it. Unfortunately, Judge Hirsch makes some conclusions based upon conjecture, and unfortunately, there's a lot of false pretenses to it. One of the things that he discusses in his order is the fact that these companies they do in fact have the ability to sort data. And he bases that on the fact that there was no testimony that was elicited to the contrary. And that was actually one of the things that I did get out of Detective Moretti, is that based upon his training, experience, and knowledge, and based upon dealings with these social media companies, they receive thousands of warrants. They're dealing with terabytes, if not petabytes, just ridiculous amounts of data, and they are not provided with the affidavits. So they do not have the ability to sort. And a lot of Judge Hirsch's opinion kind of stems from that, which is why we frequently have what we call these two-tiered warrants, which is advising the company to provide us the information, and then law enforcement will go through it because they know what they were looking for. Counsel spends a lot of time talking about how Detective Moretti can look for whatever he wants, but that's not true. He's allowed to look through the data for stuff that is germane to the case, that is within the scope of the warrant. And the warrants all specifically lay out the different things that he's looking for, whether it's location information, whether it's proof of ownership of the account, whether it is communications about gang activity. Each warrant goes through and location information for the time of the crime. They go through and spell it out. And it was one of the things that we started this motion with, I reminded the court of, which is actually in my response, which is issue number 9. A magistrate is not required to leave common sense at the door when evaluating whether information satisfies the nexus elements and supports the finding of probable cause. And it goes on a lot, but it's basically addressing counsel's argument about overbroad. But unless the warrant is so lacking on its face, the court has to make the finding that there is a sufficient nexus. And here, throughout the items sought, as well as the probable cause, he explains what he is looking for and why he is looking for it, and how it relates back to the case. And to remind the court, the threshold for nexus is very low. I know we talk about probable cause. Probable cause is a requirement just for the issuance of the warrant. There's no probable cause requirement for nexus, it's just whether it would reasonably be located at the place the detective or law enforcement wishes to search. And the court is allowed to make reasonable inferences upon that. There's even a requirement, or rather, it is universally recognized that the particularity requirement must be applied with a practical margin of flexibility depending upon the type of property he sees, and the description of the property will be acceptable for the specific circumstance and nature of the activity. And that's State v. Showcase Products.
I'll be right back real quick.
Opinion. It's in my my response, so those cases are in there. And generalizations in an affidavit regarding the likely location of evidence will not undermine the reasonableness of reliance on the warrant. That's US v. Payne, cited to US v. Grosser. There's more case law here. I'm not going to cite all of it for the court. But it's the state's position that all of this is sufficiently particularized in terms of what they're looking for. And at the end of the day, the detective in the state is going to decide what evidence that is recovered we're going to be using. If that information is outside the scope of what was allowed, we would not be permitted to use it. So the court's going to have to turn back and look at it. The defense has made no allegations at this point about what information that was obtained was outside the warrant. They just say, oh, it's all outside. And that's just patently not true. The court sat through the first trial. They know, the court's familiar with what information came out that's germane to this case.
Well, counsel, first of all, there was a difference though in the first trial. You know, a lot of information came out regarding movement on the phone, but the premise of introducing a lot of the pictures, photographs, text messages, things of that were based on the idea that the defendant wasn't claiming that he had standing in the phone. He was basically saying it wasn't his phone. At least that's the argument that was made by counsel. And therefore, there was no motion to the press file regarding this. These motions today is different. The theory of the cases, it's Mr. Dennis' phone, it's his iCloud account, it's his, and therefore it wasn't particularized. There's no nexus that's shown between the two. It was totally different.
Oh, I understand, court judge. I'm bringing it up only just because I just want the court to, I was acknowledging that the court is aware of some of the information that came out. If the defendant's claiming ownership now, that's obviously going to be a different issue. And that may actually even open up the door to more information coming in, more text messages to establish that he is in fact the owner of the device. If he is, I'm sorry, I got that backward. If he's now going to be arguing or at least acknowledging that it is his phone, then maybe some of that information won't be relevant at the second trial. But again, having not told us their strategy, I have to base upon what arguments were made before and what's laid out. He has a possessory interest in the phone. I can acknowledge that. But just because he's filing a motion to suppress doesn't mean that he's not still going to claim later down the road, because this isn't a sworn motion by him, that he's not going to later claim that the state can't prove that it was in fact his phone. The counsel mentioned Zarka-Duelis as well. I respond to that, and my response is actually under issue 7. Unfortunately, it's a very different fact pattern. Zarka-Duelis, the affidavit relied on anonymous sources. There was a 4-month time gap in the time between the crime and the warrant. The affidavit contained false statements from law enforcement, and the affidavit was not the true author of the warrant. So there's a lot of problems with the Zarka-Duelis case that are just not present here. But they also bring up the issue that Detective Moretti didn't list his qualifications, and you know, while we would all prefer qualifications because it would strengthen a warrant, there's no requirement that it actually be present in there, and that's actually discussed in issue 4. A lot of what has been raised, I addressed in my response, so I'm not going to go through all of it. I do want to point out, at one point, I do raise the issue of standing. I'm withdrawing that argument. That was based on misapprehension of the ownership of one of the devices. And that's just briefly in 10 and 11. But what I kind of want to end on is what counsel ended with, which is they want to make this about the credibility of Detective Moretti, and the court can't consider that for a motion to suppress. But nonetheless, because it's been raised, I feel compelled to respond. And they paint Detective Moretti as someone who is not credible. But the only person's testimony who has been impeached is Ms. Boutros'. She's the one who has now provided contradictory information about whether she's worked with him, what exactly happened in the room, whether there was an injury, what she saw on the device. Detective Moretti has been consistent throughout. So if we're talking about, and as the court saw him testify here, he conceded his mistakes, whether he mislabeled himself as BSO in the title or in the first line of one of the warrants, or if he lacked information. He was conciliatory. He expressed that hubris of, yes, there were errors here. Ms. Boutros was the contrary. She had an answer for everything. No matter what I confronted her with, even if it contradicted her prior testimony, she had an explanation for it. So if we're going to talk about evaluating credibility, I think there's a lot more for the court to consider than what the defense simply wants to, how they want to paint Detective Moretti.
I'm all on.
Thank you.
Your Honor, I was trying to make a motion earlier, you told me to put it in writing, and I would. But part of the motion is going to deal with what I think is germane to this right now. The state, in my opinion, has the audacity to attack Ms. Boutros' credibility by researching cases that she's done for 20 years and finding a case that's 13 years old that Detective Moretti was involved with, that we don't even know to what extent he was involved in that case. And that is what they're using for impeachment, that she doesn't remember meeting him 13 years ago. That's impeachment. Ms. Boutros, for lack of a better term, is a whistleblower. She saw corruption, and she let the powers be know of the corruption. Instead of being vilified by this office, she should be made into a hero and an example for others to follow. As to credibility, I asked you to look at the Graham case. That's when I referred to you yesterday on. Although they ruled against Graham on it because the judge on his own went out and looked at the scene and also wrote his opinion on the lack of credibility of the officer who signed the warrant, of the affidavit. It was because of information that he had gotten in a separate case. And they said, you can't use the information you got in a separate case. You have this right here in this case. This case, you heard testimony. Detective Moretti has no credibility. I'm going to ask you to grant all of these motions. Thank you.
Thank you, sir. Anything else to discuss today?
No, Judge, I think the other motions get scheduled. I think both sides have determined we're not going to be able to go forward on them until some of the remaining depots are done, because it's going to concern information coming out of that. So I think all the motions that are currently filed that we can argue have been argued. So we're going to have to work on scheduling once we're in a better position.
Sorry, Judge. The only other one I would think of is the promotional video.
Oh, yeah.
I believe we were going to have that one argued, but the witness was unavailable. We just, I guess we scheduled that one. But
Yeah, I don't even know his availability.
I would have to confer with,
Because we're not ready today or tomorrow.
You agree?
yes.
That's all I was trying to find out. What else is?
No, I think we're where we wanted to be before Thanksgiving.
If counsel couldn't correct me, but if I wanted to take a guess, I think what's going to end up happening is based on the court's order, we're going to try to get as many of the depositions done between now and that January 5th, and then we'll probably litigate those remaining motions in January.
I would have no problem.
Yes, we might do it sooner, but I just think that's the reasonable timetable.
And if we can find a day or two that works for you, we'll let you know.
That is correct. Let me ask you, one of the things that I was sent two different orders, and I know Ms. Liberty's not here today. She was sent one of the orders in, but can we talk about those orders? Is it coming up with this deposition of Lieutenant or Deputy Mullen?
yes, Judge.
We're good? You need Ms. Liberty here for that?
I believe so. I think the two orders, one was what you submitted, and she deleted certain sentences. But I was not privy to all of that.
I guess, Mike, can I ask a forward and to get that taken care of. One of the things that's in this language in the order that you had submitted, I guess, I haven't signed it, I want to talk about it first. I haven't signed either of them, because I want to talk about it. But in there, it mentions about the deposition being taken one time, I guess. I don't know about Mr. Henry. Is all the depositions that you have been arranged, or is Mr. Henry, Mr. Mathis, have they been involved in these depositions?
So just let me just backtrack a little bit. So in our original order that we provided to the defense, before we ever sent it to the court for their review, I had included the fact that Mr. Henry's attorney and Mr. Mathis' attorney would be involved, so that the step would take place once. The defense objected to that. They brought it up to your honor. And for the record, we had always agreed that Detective Colwell should be deposed the second time. So we've never objected to that. We did not require a motion to be filed or anything. They objected to that because obviously it's early on in the case, and your honor made a comment when we were in court when that was brought up that you were not going to.
I didn't want to hold it up.
Correct. And so we, after coming back, getting back to the office, said, you know what, we'll agree with the court, we'll agree with the defense, and we took that language out of our original order. Prior to any of that being dealt with, Ms. Liberty sent in order to your JA without us ever reviewing it. So when I saw that I was out of the office, I responded and said, we've never reviewed that one, here's ours, and we had already taken out the language that they previously objected to. The language that your honor is referring to, I believe, was taken out in our newest order.
I don't know. In my last conversation with Mr. Liberty was concerning taking Detective Colwell's depo once for this case and the other case, and I expressed that I don't even represent.
We agree to that. So we're saying Mr. Mathis does not need to be, his attorney does not need to be present for this deposition. We are agreeing with the court and with the defense on that. What we are saying is that Mr. Henry's attorney, Mr. Haddad, has been present for all depots in this case, so he would be present for Detective Polo's second depot as well.
So I guess there's not going to be an issue about scheduling and the other defendants not being available or their attorneys not being available. I want this deposition of Mr. Polo, because we're already started the trial. I want this to get taken.
We've already scheduled the date, Your Honor. We have no issues with that. I believe it was the 8th of December. So we are fine with that. Mr. Henry's attorney, Mr. Haddad, has always been present. He was present for Detective Moretti's deposition on Friday. He has always been present for all depositions in this case together, because for one case, they have to be together.
That is correct. He either appears in person or appears
And what's the issue with Mr. Mathis' attorney?
We took that issue out of the order, so we don't have to worry about that.
And so we understand the depot of Detective Polo in the new case.
Separate issue.
Separate issue, and will be done by whoever represents the parties
Later on.
later on from scratch, I assume.
Okay. All right. Thank you.
Thank you, Judge.
Happy Thanksgiving.
Thank you.
Everybody have a great Thanksgiving.
We're adjourned.
It should be working now. Are we working now? Yay, there we go. Wow. All right. Well, now that we figured out what happened, all right. That's interesting. See, y'all saying I didn't know I was muted. Of course I knew it. Clearly, when something's going wrong, it's going wrong. All right. So what happened there was everything, the mic gets routed through voice mod. And for some reason, that crashed without telling me. And then everything manually did what it needed to do. So, all right. Took a while to get everything un-effed up, but we did. Hi, welcome back. All right, so good. I'm glad you can all hear me now. Don't know why that crashed, but as you were here earlier, you all noticed that my browser crashed inexplicably. No, it's not an auto tuner. It's there so
if you want to do the weird voices, you can.
But that's just there, and it cleans up. It has like a background noise filtery thing. So yeah, not a boomer moment. It was just a software crash moment. Yeah, you deal with it. You move on. We did. So all right, they're done for the Thanksgiving holiday. So they should be back for more motions next Monday or next Tuesday. Until then, I guess we're on our own. What we're going to do tomorrow is do what I was going to do today. So we'll do some more YNW Melly tomorrow, which will be look at some of the motions, look at some of the stuff that happened yesterday in court, and we'll do some other things to figure it out. So tomorrow will be more YNW Melly and the stuff that happened yesterday. So we're good for that. But the big takeaway here was this motion regarding YNW Melly's cell phone. The stuff about his mother's cell phone and whatnot, that was all done yesterday. For some reason, only a few minutes of that stream are available from Law and Crime, which we'll look at tomorrow. But today, I think the big important motion. Well, there was two big motions, I guess. One is the motion related to the cell phone, Melly's cell phone, where the argument that the defense is making is it's everything on that phone is the product of an illegal seizure. The ghost who sent us this message about 15 minutes ago says, I have to disagree with you on your giving the phone back and then getting the phone back. They had good faith to believe it was the correct phone. Good faith to believe, I think they lose the good faith argument. And they found incriminating evidence. Well, you can't find, they call it the fruit of the poisoned tree, or the tree is poison. So everything you get off of that poisoned tree is also poison fruit. It's the fruit of the poison tree. You're saying it, and I don't think they should win the good faith argument, because it is, as we found out earlier, incredibly easy to check to make sure, say that to make sure that you've got the right cell phone. So let's say you have a search warrant to seize a particular phone with a particular ID. There's a specific phone, and they have to be specified. As you heard them argue, the subject of the search warrants, the affidavits to support the search warrants, they have to be listed with specificity. You can't just say we want to go find stuff owned by this guy. You have to say we have probable cause based on this, private, confidential informants, training, knowledge, whatever, based on this set of knowledge and circumstances. We believe that phone with this particular ID located at this place or on this person is relevant to this. We need to confiscate that. We need to seize that phone so that we can look for this specific evidence of this specific crime. You have to be specific with these things. And there's a great kid. You can search for it on YouTube. Maybe if I remember, I'll do it for tomorrow. But there's a deal where they had a search warrant for a guy's cell phone, and the search warrant said it was a search warrant to search for and seize a cell phone on this particular person's body. And as he was coming out of court, they served this search warrant on him. But before they came out of court, he had given his cell phone to his lawyer. And there was this big stink where they were trying to get the lawyer to give up the phone because they had a search warrant to search for and seize that phone. But because it was very specific and the search warrant said on his person, they can't go to the lawyer because it didn't say they get to search the lawyer's person for the guy's cell phone. And their argument was, well, they're just trying to circumvent this. We should be entitled to that phone. He just, he's trying to be clever by giving it to his lawyer. Well, yeah, there you go. That is clever. So that's what they're doing here. They said, we are looking for this specific phone with this specific ID. So let's say you go to execute this search warrant, Ghost, and you go to this house where the phone is supposed to be located, and you see 5 cell phones on the table. You see 5 mobile phones on the table. One of those is the one that's subject to the search warrant. Do you get to take all of them? Do you take all of them, download all of the data, and go, oh, this is the one we're looking for? No, you don't get to do that. You have to identify the phone you're looking for. They left out that very, very important step, it sounds like. They said, we want this phone. It's his phone, based on whatever, on, things we've intercepted, things we've heard, people, whatever the basis was for saying they believe that was YNW Melly's phone. They even got the ID number for the phone. They said, this is the one we need. They went there, they got the phone, and apparently they didn't check that it was the phone they wanted. So, to say that they had good faith to believe, it's not a good faith thing. It's you need to check to make sure that's what it is. And as we saw, it's just a matter of pushing 1, 2, 3, 4, like 5 buttons on the phone. It brings up the ID right there on the screen. They could very easily have checked right then and there whether that was the phone they were looking for. They didn't do that. They confiscated the phone, the wrong phone, the phone that was not the subject of the search warrant. They had no legal right under that search warrant to take that phone. It was not the one that was the subject of the search warrant. And the instant, you can say, okay, we should have checked, we just assumed, and the second we realized this was not his phone, we got that back to him instantly. That might change the scenario a little bit. You go, holy shit, this is not the phone we need. You give it back and you go, all right, apparently he's got a new phone. We need to go get a new search warrant for the new phone. If he destroys that phone and deletes everything on it before you get the new motion, that's your fault, prosecution. That's your fault, police. Not the guy who owns the phone. It's going to look bad if he does that, but that's the way it goes. But that's not what they did. They took the phone, apparently. They took it. They downloaded all of the data off the phone and were looking into it. They were looking at the data, and at some point they went, wait a minute, this is the wrong phone. They did not give that back. They did not delete that data. They kept the phone, they kept the data, and then they just went back and said, oh, we made a mistake. Apparently his phone's been changed. Here's the new one. And I'd be curious. I want to see what's in that particular affidavit to get the search warrant for the new phone. Did they say, oh, we made a mistake? Or, oh, we found out this phone was changed? Or did he say, oh, I accidentally wrote down the wrong number? Because that's going to change a lot of things. Excuse me while I cough. So so just to say, oh, we took the phone, we realized, oh my God, he got a new phone 3 days after these murders took place. We weren't aware of that, but we just held on to this illegally seized phone. I cannot agree with you, Ghost. Again, Ghost said he disagreed with me because I'm assuming it's a he. Sorry for just assuming. The Ghost says I have to disagree with you giving the phone back and then getting the phone back. They had a good faith to believe it was the correct phone. And they found the fact that they found the incriminating evidence on the phone. I don't know if they found any incriminating evidence. I can't comment on that. But if they found any incriminating evidence on that phone before going and getting a search warrant for that phone, that's even more problematic. And how do we know? How do we know whether or not they found the incriminating evidence before or after they got the new search warrant? We have to rely on Detective Moretti for that. He was the one that wrote the affidavit to get that evidence. And his credibility, as far as I'm concerned, is completely and utterly shot. And I mean, look, that's what the defense lawyer is saying. Who are we going to believe on this? Are we going to believe Moretti or are we going to believe Boutros? They're saying Boutros has no reason to lie. She has everything to lose. Her career, if she's caught lying, but they're making her look bad. Their way to impeach her for saying she said she didn't remember ever working with Detective Moretti. And they found that she worked on a case briefly with him 13 years ago. And like, aha, we caught you lying. You lying little scoundrel. And they're saying, look, that's what they're using to impeach her is the fact she can't remember seeing this guy and working on a case with him 13 years ago. Whereas we've got Moretti, who has clearly done some sort of shenanigan with another police officer asking to, falsify this. Whether it was a joke or not, it was said and it should never have been said. They've got that. They've just had him testifying that it was a clarifier. He accidentally wrote the wrong date in one of the affidavits. Oh, and a couple of the affidavits, he wasn't exactly honest with who he was, what his job was, what his position in the police department was, even what police department he was at. It was hubris. It was a hubris. So he's lied about his position and his capacity on these affidavits. He's lied about, he's miswritten the dates. He has encouraged other people to falsify data, etc., etc. Who are we not going to believe? And where Boutros has her career to lose if she makes a false allegation against another officer, this guy's got his ass to save. Because even just from Melly's mom's phone thing, he illegally, if it turns out that what they're saying is true, he illegally seized a phone. He solicited another officer to commit perjury in order to illegally recover this phone. He touched this woman based on an illegal search warrant, which would amount to criminal battery. They didn't have a right to her phone. That could amount to theft, or depending on how rough it got, it could be, it could be a greater crime than just simple theft. And I think this. Oh my God, I don't think the judge is going to exclude all of the data from Melly's phone. But that's what this fruit of the poisonous tree argument is. They had no right to take that phone when they took it. At the time that was seized, that was not the subject of the search warrant. So it's a poisoned tree. It's a poisonous tree. And anything you get from that poisonous tree is inedible and cannot be used, including all of the information that was on that. saying, oh, well, it was a mistake. Well, guess what? You don't get to convict people based on mistakes. That's how people go free. You do a half-ass police job, you do a half-ass investigation, or worse yet, you fucking falsify the evidence against the guy. You find shit and go, now we need to go we just don't know what happened. And the fact we don't know what happened shows that this was improper police work. It was inadequate. It was faulty. It was flawed. And how do you convict someone based on faulty, flawed, possibly fraudulent evidence? And I mean, if he didn't do it, this might be enough to get him off. But if he did do it, and these fuck-ups set this murderer free, that's not on Melly. It's not a technicality to enforce and honor the provisions of the Fourth Amendment to the Constitution of the United States. That's not a technicality. That's why he was saying you don't bend the Constitution to fit the evidence. You have to bend the evidence to fit the Constitution. And to say it's a technicality that this evidence gets excluded if it does, that's bullshit. That is utter bullshit. That is what is called honoring the Constitution, your constitutional rights against unlawful searches and seizures. As far as I'm concerned, unless the state comes up with something really fucking convincing, to me, it sounds like that cell phone from Melly was an illegal search and seizure at the time. It doesn't matter that they remedied it later because they didn't give it back. Like I said, if they would go, oh my God, this isn't the right phone. Holy shit, get that out of here. And they give it back to him. And then an hour later, they come with another warrant and go, all right, now we've got the warrant for this phone. Give us this phone. That might be a very different argument. But that's not what they did. Or better yet, did their fucking job in the first place and punch their 4 or 5 buttons and go, oh, wait a minute. These numbers don't match. We need to go rectify it. So yeah, Ghost, I've been ranting, not looking at the chat. If you're still here, that's why I disagree. But hey, this is Chris Mullen. See that this is what. Oh, there you are. Chris Mullen says it's pretty damning that they got a new phone after the murders, but the police should have checked that they had the correct phone in the first place. Well, that's the thing is, gosh, is it illegal to get a new phone right after your best friend happens to be murdered and you might be a suspect? No. It doesn't look great, but do you get to bring it in because of the jackassery that the police pulled? The Ghost is still here. Great. Your words are persuasive, Music Man. It's still hard for me to get to the level of exclusion of the entire phone. Well, I mean, I think it should be excluded. And like I said, unless the state can come up with some sort of wizard argument that makes me go, oh, okay. But do I actually think the judge will do it? My gut tells me no. I hope my gut's wrong because I don't think they should be allowed to use it. Do I think Melly is innocent? If you watch the first trial, I believe there was enough evidence to find him guilty of the murder. And I very, very much would have understood coming back with a guilty verdict. A lot of things don't add up, but important things did add up for me in the trial. But let's just say this actually does get excluded, all of the evidence from his cell. At first, it would be a very short trial. If all of the cell phone data, all of the cell phone stuff gets excluded, then I have to reprogram my head to forget what I saw in the first trial and look at it through the eyes of a new jury who hasn't heard that information. That'll be a trick to see if that happens. I mean, we're just gonna have to see how the judge rules on this, and we'll follow the rulings, and I'll let you know as soon as I find out. So why do they get away with language like any and all cell phones and all electronic devices on search warrants? Well, if it's like if someone, let's just say, it's more understandable if someone's accused of doing, online nefarious stuff involving young children. The basis of the crime is uploading and sharing shit. So that's a lot more reasonable to say, okay, we want all of the computers. Or if it's a financial fraud crime, everything's on computers and cell phone records. It makes a lot more sense to say we want all of the electronic equipment so that we can look at it. But if it's like a murder that's been committed, I say all cell phones. I mean, at what point does it become the fishing expedition? You go, all right, let's get every single piece of information we can, and that's what they're arguing against. It's too broad for this type of a case. You can't say, let's take everything and then we sort through it and then we go, aha, this is the relevant stuff. We found it. That's the fishing expedition. So I in this case, I don't think it should be that broad, but sorry, scratching. Well, it is 2:30 a.m. here, and we currently have 407 people and 475 likes. We had over 500 at one point. That was 1/3 of the numbers that Law and Crime had. So that's way cool. Please, those of you that are here watching this, the 410 of you that are here now watching this, check it out. Get down there and hit that like button, hit the subscribe button. Let's follow this together. Sign up for the notifications. We're doing lots and lots of Melly until this trial is over. If it ever gets over. We followed the first one gavel to gavel. We're following this next one gavel to gavel and doing all the warm up that we possibly can between now and then. The opening statements are scheduled for February, I want to say 5th at this point. I believe it's February 5th. But until then, we're going to be doing our thing here. Just doing what we can. Once, twice a week, maybe do some Melly updates. So sign up for the notifications, hit that subscription button, like this video. Let's get it out there. We got to build up that audience. YouTube's got to send out the thing. Hey, there's a lot of people that like this live stream. Let's go follow him instead of Law and Cuck. That's where we are. Lux, sorry, I gotta go. It is exactly 2:34 a.m. And here's what's coming up. Just so you know, tomorrow we'll be doing YNW Melly again. We'll be doing the stuff I wanted to do today instead of watching the live stream. But we watched the live stream, so we'll do today's stuff tomorrow. Then the next day will be Thursday, which unless Chandler Remington has something else to do, it'll be Chandler and I doing our weekly OJ Simpson chill stream on Thanksgiving morning, on Thursday morning, U.S. time. And that'll be the last time Andrea Mazzola is on the stand. Then we'll do closing arguments and the verdict, and then we will watch a new trial. Next Monday, we'll do part 2 of our Maritime Monday version of the Wager, the HMS Wager, which we started. Danny on Direct was over here at the house visiting with her husband. We did the stream yesterday together. Part 1 was wild and off the hook. It's got murder, mayhem, cannibalism, shipwrecks, mutiny. It's got all the good stuff. And we're just getting started. We'll be doing part 2 of that on Monday, and then we'll do some more Melly. People are asking about Thanksgiving for me here in Korea. Ordinarily, somebody would, group of friends or whatnot would be doing Thanksgiving. But weirdly, this year, Costco didn't. Costco would normally have some turkeys, and the local foreign community would buy them up as quickly as possible. But they didn't have any turkeys here for Thanksgiving for Costco. They'll probably get them around Christmas time, but there's no groups of friends doing turkeys or things like that. There's a couple of bars that are doing it, but Thanksgiving in a bar is kind of weird for me. Is the U.S. consulate doing something? No, the U.S. consulate here does a July 4th celebration. So it's just, what did I do last Thanksgiving? Oh, last Thanksgiving I went to my friend's restaurant, the best steak restaurant in Asia. he did a Thanksgiving deal, but yeah, not doing anything this year. So probably just have some KFC and call it a turkey. That's what it'll. Yeah, exactly. Porcelain Thunder. Probably have some KFC and call it a turkey, or go to my friend's restaurant and have something else instead of turkey. All righty, folks. Let's give you super special thanks, all of you, for being here. We had our like and subscribe poll, which was, how does the Moretti incident affect this case? 7% of you said it strengthens the state's case. 24% of you said it has no real effect on the outcome. And 69, of course, it'd be 69%, you degenerates. 69% of you said that the Moretti incident would weaken the state's case. That's the end of our poll here today. So mods, thank you for being here. Deeply appreciate it. Appreciate your time, appreciate your effort, keeping everybody in line, particularly when you have these larger streams. And I think it's only going to continue to get larger, especially once we hit trial in February. But until then, thank you for everything you do. Vice Squad chat, you are the greatest chat on the internet. You helped get me voted the top YNW Melly recap channel on YouTube, the very unofficial poll, or on Twitter. Thank you so much for that, by the way. I appreciate it. And hopefully we'll be having Bryson over there from that the conducted that poll. Hopefully we'll be having him on tomorrow. Or very, very soon, because it seems like a good decent guy. Thank you again, Vice Squad, from the bottom of my heart. All of you here watching, thank you for everything you've done. Thank you for the support. Tomorrow, let's unleash Doggo Cam, because Strawberry's looking cute as hell over there on the chair and want to share. All right, folks, have a great day. Let's see where we can send you. I'm gonna go back through YouTube and see who is broadcasting what, who is streaming what right now. Here, let's see. Content. At the content. I could do my DSP impression. Customization. Redirect. Who is doing what? Nothing particular out there, so hey, let's just send you all off into the wild. Megan is on. Megan's on? I didn't see Megan on. She's not showing up. Let me search for her by name. She's not on the list of people. It says, like, you know, videos from your followers and whatnot. And Megan Fox. No, it says upcoming. It says Megan Fox is upcoming. That's got to be a different Megan Fox. That's got to be. I mean, there's got to be like another Megan Fox out there. Right. Well, I don't see Megan Fox streaming now at all. So, all right, that's it, everybody. I'm out of here. Take care. Y'all, we'll see y'all tomorrow for more YNW. This is me, Vice Rax, saying have an awesome day with whatever you're doing, whoever you're doing it with, and however fun it is or is not. Enjoy.